Good evening, everyone. I welcome you all to the roundtable discussion of ICSI Institute of Insolvency Professionals on the IBBI discussion paper dated 7 June 2023 on measures for increasing the possibility of resolution, value of resolution plan, and enabling timely resolution. The session shall be moderated by IP Sanjeev Ahuja. I'll quickly provide you the brief introduction of IP Sanjeev Ahuja. IP Sanjeev Ahuja is a qualified IP Sanjeev Ahuja is a qualified lawyer, a merit holder chartered accountant, and also holds a degree in cost accounting. He is an alumni of ISB Kellogg's and SRCC Delhi University. He is a certified mediator by ICADR, an ADR Alternative Dispute Resolution Professional, and a resolution professional under the Insolvency and Bankruptcy Code 2016. He is also an active arbitrator and an advisor for strategic planning to promoters and corporates. So you may now start the session.
Okay, thank you, Anu. Okay, in terms of audio, are you able to hear me properly?
Yes, sir.
Okay, so let's get started. Good evening, friends. Rather good afternoon. We are here today to discuss the discussion paper floated by IBBI, trying to address some issues around the resolution plans. Of course, there are few aspects which are getting covered through the subject, as Anu just said. So possibility of them happening, right? So essentially what the board expects is they should happen more frequently with more options, which essentially means that we are expecting more RAs to come forward and actually put up their plans. Second part discusses about the value of the plan. Now, I maintain the beauty lies in the eyes of the beholder, right? So what is liquidation value? What is a fair value? I mean, all of them become theoretical when even Supreme Court has actually gone ahead and allowed some resolution plans which were under the value of the LV. So I think more important is we should be looking from the perspective of the RA, what exactly, how they value, what is the value proposition for them, how easy we are able to, make this entire case for them. And third thing, of course, we're talking about the timelines of the plans. So time spent or time lost during various stages, I think that needs to be understood for what it is worth. Are we really kind of getting into micromanagement? Are there certain processes which are overlapping? Is there a way to reduce the time? On one side, we started with 180 days. 180 became 270, then 330. All that remained on paper. I mean, it takes whatever time it takes because of litigations, clarity, adjournments. The reasons can be a number of reasons which are put forth. At the end, who's suffering? Why is suffering? What exactly needs to be done? So this, I think, is another next 90 minutes will probably be spent on these three aspects. Of course, we'll run through those, the discussion paper. It broadly covers 9 main points. And the way I propose to move forward is I'll read the relevant part and then I'll share my opinion. Of course, I'm no one to have the last word here. It's essentially, sharing a view, giving a perspective, setting a precedent, some kind of a context. And then we can always have a couple of people who share their own views with regards to what they think. I'm sure, an insolvency professional or resolution professional on the ground who's been practicing and actually viewing the things from the ground level, having that exposure experience, will have a different take versus someone who's still outside the system and looking it from a distance. So a lot looks to be a best way or an idealistic way to contain the system. Either we look at transparency, consistency, but I'm sure my professional brothers who have been on the ground, who have actually handled and handle these assignments against odds, it'll be nice to have their views as well as to what are the practical difficulties we all face once we are going ahead with adhering the CRP norms or the provisions. So I think that's important. A quick opening statements. Essentially, what is the background? I think the background here again continues to be that there is an intent to keep IBC as a code, as a statute, relevant, effective, and efficient. Hence, these are tweaks wherever, whenever required. These are tweaks which are necessary, important, and then accordingly they are proposed. So I think the intent is definitely good, but it always requires a good implementing strategy also. The intent per se alone is not going to deliver the results. How we implement, how we go about making it happen, and how we take the stakeholders along is equally important. So I'm sure during our discussions, this particular aspect also will come to fore. Because at times there's a school of thought, and to an extent, I think we would agree that a lot of piecemeal and a patchwork, kind of a mechanism happens, which at times adds to the confusion amongst the stakeholders rather than giving them the required relief. So I think to that extent, a bit more holistic approach is required, right? Whether it's a sector specific issue or it's a stakeholder specific issue, I think a bit more holistic, treatment probably is the need of the hour. So as I said, the intent for today, I mean, in terms of, the process we follow, we'll go threadbare. We'll evaluate each suggestion made in the consultation paper. We'll try and understand the pros and cons. And the synopsis of the gist, my request would be that organizers, they actually try and capture whatever comes out of the discussion. And these can be divergent views. These views, I'm sure, will come with some suggestions. There are few things which are left best to the commercial wisdom of, COC. There are few things which are important in terms of, showing the right direction to the practitioner and the stakeholders. There are few clauses and few clarifications which are required so that the stakeholders are clear about the process to be followed and they don't unnecessarily get into frivolous litigation. All put together, I think the intent is clear that more and more transparency and consistency is required, is laid out. It will help the stakeholders. But as we move forward to discuss each and every proposal, we'll see whether it really adds to the comfort of the practitioner and the stakeholders, or it kind of adds somewhere to the confusions at times. A smaller statement which which can actually get fit in at any point in time, but I just feel that let me quickly run through these few notes or my suggestions at a much larger level. This is a more of macro statement. Now, this paper is about a resolution plan, and I said resolution plan is a proposal which comes from a resolution applicant. A resolution applicant is a white knight. I think resolution applicant is the only stakeholder who puts money where his mouth is. The rest of the people are either trying to enforce the law, implement the law. Somebody is looking at a resolution, somebody is looking at a recovery, all put together. But here is a resolution applicant who really is willing to write a check. And anything and everything with regards to IBC and or resolution plans, whenever we discuss, to me, it's very important to keep the perspective of the resolution applicant in mind. Right. So we are thinking about insolvency professionals, and you add more and more and more, guidelines and provisions and rules for them to follow. We keep talking about the COC, agreeing, not agreeing, talking about the commercial wisdoms and all that. We talk about authorities, we talk about adjudicating authorities, regulator, policymakers, everything is fine. How many times we've really figured out, and how many times we've really spent enough time by having maybe, round tables with the potential or existing resolution applicants, bidders, investors who are really putting their money, which essentially is the main yardstick of how this IBC is going to be, how much, effect and efficiency we have achieved. What kind of a success have we been able to get? I think that's going to be the most important exercise at a point in time whenever we have to have it. We can always have our different parameters and different, yardsticks to say IBC is positive, is being successful, not successful. You speak about resolution plan, you need to speak about resolution applicant, right? So that's something which I want to really, focus a bit more on, because on one side we are saying lesser resolution plans, right? Have we been able to give a true clean slate to a resolution applicant? Have you been able to ensure that there'll be no frivolous litigations? It won't be dragged into, unwanted, drags and, the delays and all that. Why we are saying less value, why we are seeing less value in the plans. I think again, that's more of a repetition. LV all said and done, which somehow became a benchmark, is not a something which is a underwritten, number by any party. It's probably the best estimate in a scenario, right? You want to value a company, a corporate data assets as a going concern, but in reality, any CD which comes under CRP or liquidation already has a taboo. Already, people are skeptical. Already, we have seen, I mean, on the ground also, we've seen the customers and the vendors behaving very differently, right? Including the authorities for that matter. So at the day end, the valuation, whatever be the number, I mean, it can give you some kind of a benchmark, but it cannot be such a rigid or a stringent thing. I continue to say the beauty lies in the eyes of the beholder, the person who sees value. Nobody's going to come out and do charity at the day end. It's a very, very, a clear fact. It's a commercial transaction. Somebody, if it doesn't have a buffer in terms of, the positive, the surplus, the profits, what he can eventually make, nobody's going to come forward and make a bet. Similarly, I think somewhere the reasons which I've given are also affecting the timelines as well. So RA is privy to this entire circus which happens right through the CRP or the liquidation at times. But for them, more and more certainty which we are able to provide as a collective group of stakeholders, I think that is the most important fact and the aspect what any RA. So my interaction with maybe number of RA's potential, successful, including ARCs, funds, VCs, anyone who's remotely wanting to see and explore this particular space of IBC, they're saying, well, we still need to wait. We still need to see it evolve. We still are waiting for, the markets to mature. We are waiting for the stakeholders to mature. There's a different discussion which is required. And you have to understand the mindset of either they come as aggregator or they come as a bidder or they come as a savior, whichever way we look at, they're writing a check, right? So somebody who wants to write a check, he needs certainty. Nobody better than them who understand the time value of money. So from that perspective, I think RA at every stage in life, in the process, whether it's a CRP, liquidation, any process which we are kind of getting involved, you speak about a resolution plan, you speak about a resolution, or in as many words about recovery. If somebody is not willing to write a check, somebody is not willing to put in money where the mouth is, how exactly are we looking at a success? So I think that was something which I thought I need to share more, again, as my view, but also as a collective thoughts, which I could gather when I interact with various people, various stakeholders across. So anyway, coming back to the logistics of it. So I get started. I have some notes, at various places in the in this document. So I'll try and focus on the specifics. Then maybe suggestion would be, since I see about more than 100 people today, so that's I think a great attendance. I'm just sure that probably the only reason why a lot of you are here is not because of that one CPR. I think there's much more takeaways from today's session, and the intent would be to make it interactive for the simple reason that every person would have his own way of dealing with the law, the way you implement, the way you interact, the way you manage your relationships. So even the same provision can be applied and can be viewed and can be assessed differently by different people based on their experience, whether in IBC or outside at the day end. So it's I think it's important to have few views, and even if you don't agree, right? I mean, for example, I'll be sharing my views. So it's not a strict opinion or something. It's just a perception as to how I think something probably would make sense, something will fly, or something might add to the confusion. So similarly, suggestion would be that from your side, after every specific provision or a clause is discussed, we can have 2-3 different views, divergent views, and if we are done in time, then we can open it for a larger group for a Q&A, and we can take it from there, right? So let me get started. Okay, so the discussion paper says the measures for increasing the possibility of resolution. One, so more and more. Second is the value of the resolution plan. So the higher the value, which is like, goes with the premise, the maximization of the value of the assets of the CD. Third is enabling timely resolution. So they're trying to like, attack or address three different aspects with regards to the resolution plan. And of course, they start by saying that, primary objective is the time-bound resolution and maximization of value of assets, which I think all of us know by heart now. The challenging part is like, on the ground, we don't see, much being done in this space. So let's see how, to what extent these clauses, these proposals will actually, benefit. So it says, however, two major criticism against the resolution process are that the fewer companies are being resolved, the lesser value realization with lesser value realization, and the time taken for such resolution is longer than what the law prescribes. So again, spending, just, 10, 15 seconds on each, fewer companies. Initially, we used to say the resolutions are coming far and few because a lot of companies which were dormant, which earlier used to be part of the BFR regime and all that, those are the companies which have been pushed to IBC, and hence what exactly can you expect? So that was like, one reason given to the lesser number of resolutions coming in. But today, sitting after 6 years, if we keep saying the same thing, I think there is something wrong, right? So we can't keep changing or pushing the goalpost. So it's a serious matter, right? So are we really understanding what exactly is plaguing the mechanism, system, process, or we are just saying, okay, let's try something else. If it works, maybe in 1 year, 2 years, we'll again, like, say, come out with some different reason or something. So let's understand why fewer resolutions is our way of handling, is the way of implementing, is the way of enforcement, the quality of RAs, anything and everything. Is it together like, contributing to the fewer plans, a point to be discussed. The lesser value realization, I think this always would be a challenge because half of the time we are really struggling between the two extremes. One is the resolution, which may or may not lead to a recovery, right? Let's be clear. In the sense, I mean, immediate recovery. So, and on the other hand, there is a section which actually say whatever they say, but they're actually looking at recovery. Now, if you're only looking at recovery, I'm not sure whether true resolutions are happening or are possible, because the entire mindset approach is going to be different. So we need to be somewhat clear. It's a kind of a, otherwise a lip service or almost a hypocrisy that we keep saying resolution. Once we are part of the COC, irrespective, OC, FC, whichever way, all we are concerned is mera paisa, the earliest I can get money. Higher the amount in minimum time, if I get, then I'm happy. Right? So what exactly is the resolution? How do you evaluate a resolution plan? Is the resolution plan which says, okay, this company can actually, do wonders in the next 3 years, 4 years, 5 years, right? Everyone should be like, happy to take equity because there's a lot of upside. You will also get, your money is paid and everything. That resolution plan may not succeed, may not fly. Versus a plan which says, okay, upfront, I give you, 20%, 30%, whatever number, then I do whatever I do. So even if there's a lot of potential, let the upside be mine because I'm the equity holder and that's the way I'll. So if given a choice, and when we sit there in the COC, what exactly is our driving force? What's the trigger? What are we like, trying to achieve by sitting there? What is our mandate? Equally important. And we normally don't sit as an individual. We sit as a representative of some organization and all that. So I think that's where, the valuation and the timelines and everything kind of, props up from there. The paper very nicely accepts that there are challenges which exist in both the market-related activities to be carried out by the insolvency professional and the committee of creditors, and activities under the adjudicating authority's mandate. So, mindful of the fact that, yes, there have been challenges with regards to these two aspects. Okay, so now I think we go one by one. So that was the background. So the first is timeline for providing information for assignment of debt. There is a reference to Regulation 28, where it says that in case one creditor feels or wants to assign its own debt to a different creditor, then it can be done because the regulations provide so. And we go in detail. It says under clause 1 of 28, if they decide they can do it, you have to inform the IP concerned, IRP or the RP, all that is fine. Somewhere it does mention clause 2 that the RP has to notify of each participant and the adjudicating authority of any resultant change in the committee within 2 days of the change. Okay, I understand everything has been made with a mind frame of 180 days, right? So wherever we can cut down on the time. I mean, at times you are happy that if something has happened by, in the morning, at least we're not getting expected that, by evening before you leave office, you have to inform someone. But these timelines are really crucial, 2 days. Okay, but here the whole attempt was actually to put a timeline for a creditor who wants to assign to somebody else in what time frame they are supposed to inform the IRP or the RP concerned, because there was the law was silent. There was no provision for which 7 days are being given. I see a hand raised, Mr. Jain, Jitenderji. You wanna unmute and probably go ahead?
The definition of financial creditor and operational creditor, it has included that legally assigned.
Yeah.
So few practical aspects which we need to understand. And there is a dilemma whether RP can adjudicate, as in Swiss Ribbon Supreme Court said RP has no adjudicatory power. Again, now there is a circular from the NCLT, we don't know under which provision, but it is there. So whatever report or particular intimation we file with NCLT, they ask us to file in the form of an interlocutory application. So these are the being challenges. It would be more appropriate whenever there is assignment of debt, let the assigner and assignee file an application before the NCLT, and NCLT passes an order to replace the party. That would be better for all of us. That would be rather faster, because it is coming to RP and RP then checking what is right, what is wrong, whether it is legally assigned or not. It remains a dilemma. So it would be better if our adjudicatory authority itself decides this and replace the party in the COC. That is my suggestion, because it would be more convenient, not from the RP's perspective, but practically. At the same time, it will save time, things coming to RP and getting stuck, challenged and questioned by other lenders, which will take more time, and then it is going to NCLT again, where RP has to file an application. So let everything go directly to NCLT and they do it, and RP will comply accordingly.
Yeah, so I think you made a very relevant point, and it touches the process on two accounts. One is, what is the role, authority, duty, responsibility, obligation of the RP? Depending on the order, depending on the forum you go to, I think people have still a different view about the animal called RP. Let me tell you, somehow, right? IRP, RP, whatever, because the moment we say, so somebody would want us to be called as an officer of the court and the trustee of the assets and the fiduciary relationship and everything. Authorities will come back, come after the individual, even for, the some violations of the corporate data, the management, which have happened prior to CRP, because you are the chosen one. You are everywhere. So even if there is a summon which comes to a company in which I'm RP, it will be of course, it says through, but then summon is in my individual capacity. And once you go there, and then, the entire response is very different. So from that perspective, yes, this confusion about what RP can do, what he can't, this continues to be in a way a gray area, including the point you made about adjudication as well. I understand the, Swiss ribbons, and there was a reference in SR Steel and probably in a couple of others that you can't even accept or reject, right, the claims. And this is going to hit us once we go back, once we go down, discussing some other ones in terms of, that if you can't reject something, then why even mention it at any point in time? So that is one. Coming back to your other point where you're saying that it should, the assigner assignee should actually go to NCLT. Now, if you see, and again, we go to, the next proposal and a couple of them after which they are, somewhere what used to happen at NCLT, including of the delayed claims, for example, which we'll come back to, a bit later. And people had to go to NCLT and get a direction, and then it comes back to the RP concern to actually accept or reject whatever. That even that particular thing is being now given to RP, that for continuation also, you are expected to put up an application. So if there are other pillars who are not able to do what they're supposed to, what they were expected of, right, because of infrastructure issues or because of whatever, are we saying that if there is somebody who's lagging, or if somebody who's not able to fulfill what he was supposed to, let it go back to the IP concern? I mean, how fair would that be? So actually, in a way, I'm endorsing your point that this is a big thing, right? It leads to a change in the creditor from one to another, FC to OC, FC to FC, OC to FC, OC to OC. It can be anything. And because of that, by virtue of the change, it also results in the reconstitution of the COC in a way, which is important, where our RP is obliged to inform the adjudicating authority, again within 2 days, 4 days, so many restrictions we have. So this being a serious thing, this being an important thing, and this is not something where it's not an informed call. It's not a FC or a OC will come to you and suddenly say, oh no, I don't see a good reason why to continue, so let me assign it. It's a thought through reason. It's a decision which is being made, and more likely than not, we are talking about an entity where maybe the board of that entity would be required to be involved before taking these calls. So since it's a serious, important thing and an informed call, let that not be very simply be just informed to the professional who now is under the obligation to run to AA within 2 days, right? Because it can happen more than once. Who's stopping? Across the period of 180, 270, whatever time, there are no timelines, right? At any point in stage, we have seen in the fag end towards the CRP also, there are banks which are actually assigning their desks to ARCs. So, which means that half of the time you also need to be very, very mindful of the situation, that the moment there is an assignment leading to a reconstitution, so somebody has to rush to the adjudicating authority again by filing an application and all, because having, stating it still seems to be a simple statement. Okay, within next 2 days, within 3 days, whatever timelines you get, please make an application, apprise. But there are logistical nightmares. Depending on what time are we talking about, at what stage in CRP, what you are at. I think there's a lot of burden already on the RP. And somewhere I have the urge, maybe eventually I wanted to say this. I think with so many, requirements of compliances to be made at every stage, and entire obligation being on the individual, and in today's context, maybe on IP entity, whatever it is, there is a lot of compliance burden. So are we moving to a situation whereby you might have to split, this entire process into two? There is a section who is only looking at recording and compliance management. And then there is a portion or a different aspect where, somebody is looking at the marketing and the resolution part of it. It requires a different mindset. If you're totally bogged down by, the compliances all the time, then I think, and you are picking up the compliances which other stakeholders could have done. So I would agree to an extent that, maybe this could be a good idea that, why don't they make an application? It's a serious thing. The assignment could have happened even prior to CRP. Nobody stops them. But if it's happening in CRP, then let this be kind of, be in the records of the adjudicating authority. But minimum what I wanted to also say, because you gave a slight different, tangent to this discussion. But what I wanted to say, the creditors, assigner and assignee are getting 7 days to inform as per the proposal. But the poor IP continues to have only 2 days. So people can take whatever time, 180 days continues to be sacrosanct for everyone. So if we are so concerned about that limited time what we have, why not only give them 2 days to them also? And if they are busy, or if they are preoccupied or whatever, I think so is the RP concerned. So somewhere maybe the minimum what I thought, in addition to what you suggested, they can reach out. And again, here I say that maybe the organizers, Anu, I'm sure you people are noting down, the suggestions, the issues which are being raised and the challenges. And then eventually you can all put it together, and before the deadline of 27 June, if you can share it, with the IBBI concerned officials. And I was told that we'll have some officials from IBBI also who will attend. Anu, can you confirm? Do we have some representation? Hello, anyone from ICSI?
Yes, sir, there are people from IBBI, I can
They are,
confirm.
right? There are. Okay. So, I mean, I'll definitely, welcome, encourage them in case they want to, just step in and probably give their side of the view. Otherwise, I think the discussion which is happening is more from the perspective of an IP on the ground, in terms of what are the real or the practical challenges which we face and which we might have to face because of these, proposals, or some tweaks are required. So one suggestion is 2 days for the RP to inform and 7 days for the creators. Maybe we should have some parity, at least, we look at a time in between, so 3 days, 4 days, or both of them, something like that. Then if I were to say, Dharmendra ji, you have your hand raised, you wanna come in now on this point, please go ahead, unmute and let me know.
Yeah.
Hanji.
Hi, Sanjeev ji.
Hanji.
Yeah, I just wanted to add here what you said. This is, if we see in the liquidation process, this was more prevalent when this assignment was informed and this thing. So it is a matter of contractual obligation, one financial creditor or one creditor assigning this thing to other.
Yeah.
And in terms of the contract, so it is a registrar function RP is performing or IRP is performing, that he is making note of this change of the debt through debt assignment process, and that needs to be informed through updated claim. So it is a very normal thing, and since fortnightly or monthly updation of claim, or even before every COC, there is a practice that RPs follow, that they update the claim. So I think instead of 2 days, it should be whenever the updated claim register is filed, this should be notified in due course, not 2 days. It is my humble opinion that whenever updated claim register is filed, because once first claim register is filed and the committee of creditor is constituted, thereafter on every update, and normally the frequency is before the COC meeting, RP does this, and it is taken note of by COC members of the updated claim status.
Right.
So the committee of creditor is updated accordingly. So why to rush for this thing of 2 days? It should be in the usual course of updating this thing, and RP should be given liberty to inform. And there is, as you rightly said, there is no question of accepting or rejecting. This is an information that comes to RP, that once this assignment takes place, that's a contractual obligation, and that assignment has already taken place. That is not under the domain of RP to accept or reject the assignment.
Yeah.
Because he is just doing a transfer of name from one creditor to other creditor, and
Right.
it has to be informed to the adjudicating authority in due course.
No, point taken, Dharmendra ji. Usme
Yes.
there were two quick aspects which I'll quickly address. One, what happens, as I said, in piecemeal over the period, we figured out that RP should do this, RP should actually keep updating the the claims and all. And your point that he in any case is obliged, or rather there's a practice that before a COC you normally do that, because if the constitution has changed, then you need to apprise. Now concern is if there are in a big case or in otherwise a complicated case, if there's a regular COC, this is just adding to the, botheration and a kind of a recurring exercise. But equally important is when you say it should be informed in due course. I think there we should have, it's not about 2 days or 7 days. It's about you need to put in some time. Otherwise, till today also the creditors, if they were to assign and then they sit pretty and in due course they'll inform. I think somewhere the timelines are important. And normally what happens, these timelines are so that you understand that this needs to be done as part of your monitoring document, as part of your SOPs, as part of your timetable. You know कि ऐसा कुछ होगा तो within some time you need to actually tell whether you do it, your team does it. That's besides the point. So from that perspective, the idea was if you want to give 7 days to the creditors, because the due course will be like evaluated and understood by different people differently. Due course, Saturday, Sunday छुट्टी थी, Diwali, Holi छुट्टी थी, तो due course में working business day होता. But in IP thing, we don't work like this, right? Every day is a day getting counted in 180. So I think 7 days made for them and 2 days continue for RP, that is unfair. Somewhere in between, they take 3-4 days, we take 3-4 days at best, and this is within. If you have the wherewithal, might as well get it done the very next day, the very same day, right? If you have your lawyer or something like whichever way you want to work. So that was just to maintain a balance. Equally important, what if they don't inform, right? What if they don't inform?
Right.
So is
Here
there
the penalty? Here the penalty to
Point is,
IBBI.
I'm not even suggesting.
And
All I'm saying is,
as Mr. Jan said, this is in form of IA. So all the IA has got a process. There is a defect. You have to remove
that's
that
the point.
defect, get the listing.
Yes.
So
the whole idea is, sir, why keep adding to the procedures, right?
Exactly.
Why not sensitize people? So what will happen is if they don't do it, then tomorrow there'll be a circular confirming that, okay, you could have asked them, or if there's a delay from this side, you could have done that in 24 hours, or put a penalty, whose obligation is to put a penalty, RP. And then there'll be an application by the creditor concerned, why is because we had a genuine reason. So why? So I mean, let's try and sensitize people and not make, the kind of, rigid lines. Otherwise, what will happen is even the implication repercussions will have to be borne by someone, and in absence of somebody else not taking up the onus of the responsibility, again, the vulnerable IP who's on the ground will actually, get, questioned unnecessarily. So, Vikram ji, you have raised your hand. So very quickly, because I think we are still on the first point, but good to have
Yeah, so Sanjeev ji, my point is the amendment proposed is 7 days, right?
Yeah, it does.
Now these timelines are anyways directory. And they are not
it takes
mandatory.
us to a different
No.
discussion.
So my simple point is
जी.
that we even have 90 days for submission of claims.
So उस पे तो आ रहा हूँ, वो तो बहुत interesting है topic.
The point is that all these timelines are the timelines are directory. Then whatever amendment they propose, how does it solve to reduce the timeline? The point is, if suppose 100th day you get an assignment agreement, can you refuse the assignment?
No, so their point is, as when you do it within 7 days, you inform, right? So the point is, you get informed by the assigner and or assignee. You go to adjudicating authority, you inform them. Your job is done. If it happens on 100th day, 102nd day, you should be doing your bit, right? They'll take 7 days after whenever they do the transaction. Within 7 days, they are supposed to come back to you, but you get 48 hours. So that is what I was saying. Let's be fair to, also the implementer, the person on the ground, by giving them equal time, so 3-4 days for them, 3-4 days for us. And I think that should do the trick. But I understand where you're coming from. On the claim side, of course, we have a higher, deeper discussion. Sorry, I'll have to move a bit quickly. Mr. Sushant Das, you have your hand raised, sir. Please go ahead. Yes, Mr. Das.
So actually, I didn't want to speak on this assignment of debt. I wanted to speak on the claim part of it.
So let's wait for a while. Let me reach there.
So actually, I have to go for another meeting. So I'll just make a point in the sense that a point in respect of a why that burden has been why we are trying to shift the burden to the resolution professional is not to, because this point has come from the one of the CRPs of PAN card club, wherein about 15 lakh claimants are there. And it was a challenge to reach to those claimants. And in most cases, they have received a lot of late claims from say about 1 lakh people after the date, after 90 days. So now the challenge is whether he should file a consolidated application before the AA, or he becomes a respondent in these applications. So it has to be, we have to find out a process. It's not a like a request had come from the resolution professional himself that it will be better that he files a consolidated application on their behalf.
Right. No,
So,
point taken. But
yeah.
I think what we're trying to do, sir, here is we are trying to
So
make a rule
I'm
for
just
an
explaining
exceptional
the
situation.
I'm just
Yeah.
explaining the situation.
Ji.
If you come up with a better alternative, we can discuss it. But I just wanted to give a context. It was not to shift the burden to anybody.
So
It
that
was
is
to
what,
find
that
a
is,
solution.
okay. So intent can be anything, sir. Intent can be
Hmm.
anything, but what exactly comes out of the proposal is shifting of the burden for sure. Number one. Second thing is, you under no conditions in any
Okay, you can debate it. I just
of
wanted to
course.
give it context. I'm not discussing anything.
All I'm saying is, you can't have a rule for every exception. You exceptions, outliers will have to be treated differently as an exceptional point where NCLT can actually, create a carve out through their orders. But why make a rule where it has the possibility of getting misused or delayed, as an option given in the rest of the cases? So I understand. I mean, since you have to leave, otherwise, I think we would have had a good debate on
No,
this.
no, my officers are there. They will note down
point taken, sir.
whatever
Point taken.
discussions take place.
Point
Yeah.
taken. Absolutely.
Only one thing for Mr. Das, sir. See, in
Ji.
many cases, consolidated applications are being filed by the liquidator, especially in case of liquidation. So you can't compare it to the CRP or liquidation. If I remember correctly, the PAN card club is in liquidation, not in CIRP. So in CIRP, one can think of filing consolidated
No, it
application.
is a CIRP.
But so CRP, so then I don't know. But in liquidation, we have definitely filed
No, no,
consolidated
so again,
application.
let's treat this at a higher level. But I get his point. He says this is a request, and they are trying their best to put up this proposal, which probably can address the issue. Once we reach, I think we'll have a deep dive on this thing, because this can open up, a different Pandora box. So that's a concern. But yes, we need to come back with a constructive suggestion to them as to what exactly can fly. Otherwise, this currently as the shape it is in terms of the proposal, this can actually get misused, or it will give different, signals to other people who can get complacent, right? So we have reasons.
So the proposal is from PAN card club and such CIRPs where a lot of late late claims are being
Right,
filed,
Theek.
and also from adjudicating authority,
Sir,
which they
simple.
say
Okay.
it is very difficult for us to hear 100 applications. It
Sir,
will
totally
be better
with you.
if those instead of those 100 applications are consolidated at one place. So
Aapki baat
this
theek hai ji.
proposal has come from two places.
Point
So
taken,
I
sir.
think
देखिए ऐसा है, again, I mean, since you have to leave, but let me make again a quick statement. MSME के लिए कुछ करना था, 29C और H को हमने carve out बनाया, 240A लेकर आए. Similarly, NCLT for a scenario like this, जहाँ पे class of creditors हैं, जहाँ पे ढेर सारे लोग हैं, you can always have a carve out. Do not make a change in the main regulation. Otherwise, what will happen? People will read the law as is from the day the amendments are made. And once they do, nobody will remember पहले क्या होता था, दिल से कि बहुत टाइम है, बस आराम से देंगे. We are again missing out on the point. Resolution applicant needs to be given certainty. Now, these are cases which are to be treated differently because 1 lakh हैं, 15 lakh हैं. These are outliers. I wish we could have a rule for all the exceptions, but exceptions need to be treated absolutely with you. All I'm saying is a carve out is required. So we can say, जब भी एक situation ऐसी होती है जहाँ पे class of creditors, because आप लोग 3 AR की एक्सपेक्टेशन है इन अ क्लास ऑफ क्रेडिटर. अगर ऐसी सिचुएशन आपको पता ही है कि देयर विल बी लॉट ऑफ पीपल, सो अगर वो है उनके लिए क्लेम्स का मैकेनिज्म अलग कर दीजिए, एक अलग से सेक्शन आ जाएगा कि ऐसी सिचुएशन में इस कंपनीज में हु आर लायबल टू बी पुट अंडर दिस कैटेगरी, देयर विल बी अ एक्सटेंडेड टाइमलाइंस. दैट्स ओके. Coming the way it is coming now, I think that is what can be adding to the challenge. But once we go there, we'll have because I also have my notes, prepared accordingly. So thank you, Mr. Das, for the, intervention. So point number 2, seeking information from personnel of the corporator. Now, somewhere it says, assistance, of course, is required. Otherwise, as per section 19.2, you can always, rush to adjudicating authority with regards to, any complaint or lack of cooperation from the personnel, management, promoter, or corporator in general. That's okay. Further, it says the regulations do not lay down how the control and custody of assets and records will be taken over. Again, a small concern. How? Pehle tha what? Now it is becoming how. So essentially, a request to be made to the policymaker here is, people are coming with 10, 15, 20, 30 years of experience, right? Now, 6 years of IBC is also there for the earlier people to share their experience, whether those are in 50 hours or generally through webinars and seminars, or people working with each other. So every person will have a slightly different way to handle the things. They'll have their own teams. The CD and the people on the ground will behave differently. Some will be, very cooperative. Some might be hostile, and half of the situations are in between. At times they're hostile and at times not. Now, how the moment we come, we are actually drawing, lines. We are just not showing the direction, which is what ideally should have been the case. Apart from the direction, now we are actually laying down the path. Aise karo, aise hi karo. Because even if you say aise karo, then by default it will mean कि ऐसे ही करो, और अगर कुछ और किया तो वो गलत हो जाएगा, right? Because regulation, all said and done, subordinate legislation, law of land, as far as a layman on the ground is concerned, or the stakeholders are concerned. So that is where I'm saying, I think we also need to be very clear about what is the intent till the time it comes as a guideline. But the moment it becomes a regulation, then people start getting into interpretation, and half the time in the courts we have seen the applications are primarily for interpretations which are swing right from harmonious to the other extreme of strict interpretation and suiting the context. The bottom line is, in the larger interest of the schemes, the premise of IBC is to save the company. So everything goes for a toss. So more important is, let's not kind of make it rigid. Let's keep giving guidance that this is probably the best practice or could be the best practice, with enough flexibility for a professional on the ground to take your pick and maneuver a bit, but stay within the 4 corners contours of the law. Anyway, this was more of a initial reaction. Once I read the proposal, it speaks about 18.1f, 18.1a. It says, if such list of assets as per the balance sheet or in any of the records is not readily available, it's part of the proposal I'm reading, CD should prepare, and in case they don't, then the same may be prepared. So see, small important terminologies which I'm focusing on. CD should prepare, and if they don't, then the same may be prepared by the RP. This may definitely will have to be read as shall. RP does not have an option. And by the time we come down to the proposed regulation, it actually speaks of shall in both the ones. So CD shall, and in case they don't, RP shall. What exactly happens to CD who is not cooperating? The only option is 19.2, along with the list. Now, that is one part. Okay, we are wanting to have more clarity, more consistency, records on the ground, so that we know what we are handling, and every asset of the cooperator is within the know and under the control in a way. The concern continues to be, the list of assets and records shall be signed by the parties present. I'm still okay. And by at least 2 individuals who have witnessed the act of taking control and custody over such assets. Why, sir? Now, essentially what is happening, first of all, is going to be a Herculean task to an extent in a scenario where the CDs and their teams are hostile, to bringing them to our table, agreeing to a list, which is agreeable, acceptable to both the sides. One challenge by default. Then make them sign. Half the time the directors are not signing their balance sheets, reports, records, this, that, whatever. We somehow will manage. Okay, requirement of the law. Otherwise, also, I think it's good that tomorrow we should not get into any kind of a friction and conflict. But getting two people, more individuals as a witness, how on earth I would find? First of all, half of the Janata does not vote about IBC. Then in that scenario, I can't have an individual who's like, already connected to CD, because that's not a witness. Essentially, I think what the witness expectation here is a independent guy. So to get an independent guy, you need to explain him what is his locus at the end. कोई शादी में नहीं है कि दो बंदों को लेके जाऊंगा कि कल को डिवोर्स के चक्कर में लफड़ा होगा. यहाँ पे तो getting those individuals from outside and then fixing a focus that tomorrow if there's a debate or a conflict or an issue or a dispute, that means we need to reach out to them. So they need to be know of all this arrangement. Why would people want to even get it embroiled into all that? So again, I think karo transparency, consistency, record keeping. I think we always were there on that. But adding these irritants are going to become, a botheration for the RP. All said and done, only RP. CD, wo apne logon ko wo, matlab, they are not allowing them to cooperate. On top of it, if two individuals, outside witnesses, they can't be connected to CD under no condition. So it's difficult. If I have to tell someone, he in any case is still not independent, right? I might have to plead, someone ki kar do. Otherwise, wo arrangements honge, chal yaar kar de, dekhi jayegi. So why we don't think through on these things? Because this, to me, the witness part continues to be, I've not been able to reconcile, but anyway, I'm happy to, have a couple of views on this thing, because primarily point number 2 ke andar yahi tha with regards to the, handing over and taking over. So list wo banaye, nahi banayenge, hum banayenge. It's part of your SOPs now going forward. Let's agree, and okay, it's for the betterment, larger betterment. But the witness thing, somehow I'm not able to, grasp or understand or absorb. But let me hear. Haji, Mr. Jain, bataiye your views.
Sir, as you rightly said, firstly, this regulation anticipates that there is a cooperation from the management, because the word party shall make. Who are these parties? I am the one. Second party is not cooperating. How they would make any, what you call, a joint statement, or why will they sign, and how would I force them to sign? And again, the witness remains a dilemma. No one wants to become witness. Even the promoter is not going to allow you to inspect. Then if you can't inspect, how you can make the, what you call, list? So these are the practical things one has to understand. Again, at the same time, let us see the section 7.0. 7.0 has enough provision. At the same time, 236 is there, which gives power to IBBI to prosecute. Section 7.0 has provided punishment of 3 years if these kind of records are not provided by CD. I am not sure how many IPs and why IBBI has not prosecuted such promoters under section 236 read with 7.0. It is for them. If you don't set the right things or the tone, it is not going to change. You just, what you're doing, you are asking RP to do something extra, rush to NCLT. It is only an additional thing. Instead of going straight, you're asking them to go bypass. It will not solve the problem. The solution lies with IBBI. Let them read section 7.0. Let them read section 236. Why it is incorporated in the statute. When they are going to use it, for the benefit of RP or for the benefit of promoter. By not using it, they are just logging NCLT. Hundreds of applications are filed before NCLT for the purpose of section 19. It is not going to solve problem. Instead of going straight, you're asking them to go bypass. And even in that bypass, you have created certain hurdle. So I'm not sure how it is going to help any IP or to the system, or it will expedite. You start using section 7.0. You make a simple statement like in particular provision like in Old Companies Act. Let the promoter file a statement as on date, audited, unaudited, whatever. And if they don't file, you can simply prosecute them under section 7.0. Instead of doing that, you're asking RP to do blah, blah, blah. It is not going to help. Even if you say you will take it from the last statement. What is the last? In many cases, we don't have a statement, audited statement for last many years. How can I take a statement of 4 years old to reconcile for today's purpose? So all these, the practical side, one has to understand and appreciate. This is not the solution. You are just asking RP to, instead of going straight, go bypass, which is increasing your work and delaying the things further. One has to.
Yeah, that's true. Absolutely, point taken. And in fact, at every point in time, at a drop of an hat, if we keep saying 19.2 ki application laga do, I think we have enough, proof that there have been so many 19.2 applications and they are not, creating the desired impact. And this suggestion of yours, which I was also thinking that, the CD normally, right? Normally, not in all the cases, but normally they come and protest or they object to the admission of the CRP. So at that point in time, why does it become a kind of a necessary submission from them with regards to the accounts and the records and the assets list or something? Put some pressure, put some onus on the on a different stakeholder. And in case there is a gap, then maybe RP will also try and see what best he can do. So, so somewhere I think let's not, keep it as a simple solution that if anyone else is not doing what he was supposed to, let's put, the onus on the RP. I think it's going to be really, a big challenge and difficult. Dharmendra ji, I think we'll have to slightly make a rush. मैं आपसे फिर थोड़ा देर में check करता हूँ, if you allow, because we'll have to be sensitive to the time. It does take time because these things do, require a kind of open house and, more open debate. And we are still only 2 out of 9, frankly. So I'll just quickly rush. So third is, one of the most important ones, which probably can have, some reactions. So modification of timelines for submission and consolidation of claims. So my point, initially it was the last date mentioned in the public announcement, which was about 14 days approximately. Then it says, or no later than the 90th day of the insolvency commencement date in case of a delayed submission. So this or essentially defeats the sacrosanct or the relevance of those 14 days mentioned in the public announcement. Let's also try and make these changes as we move forward. उसका फायदा ही क्या 14 दिन बोलने का जब अभी law में लिखा है 90 days. So it's always the larger, the extended time will be appreciated by everyone. कि यार अभी क्या जल्दी है? मतलब in my case, in the cases where we have to suggest, we say okay, नहीं कर सर, हम रह गए सर, हमारा application time पे claims नहीं हुआ. That's okay, 90 days लिखा है. तो अगर 90 days लिखा है तो 14 is in any case out of the window, right? It's no more relevant. So let's try and now also weed away, which is becoming redundant because of the amendments which are taking place. Number one, now it says, however, the current timeline may pose constraints for certain creditors, particularly in complex insolvency cases with numerous stakeholders. Now, of course, Mr. Das has suggested it's a very peculiar case and a demand, and accordingly NCLT also made a reference to that. But I think this is a very specific case we are talking about. 1 लाख थे, 15 लाख थे, NCLT के लिए consolidation मुश्किल थी. I understand outlier situation, a very specific situation. And again, I repeat exactly the reason why we had a class of creditor in a case of a JP, which led to home buyers becoming a class, then a FC, then getting represented by AR. If that be the case, something similar can happen here as well. जब यहाँ पे class है, right? Why don't we, और उसके बाद हम AR की भी बात करेंगे, extending the role, पैसा भी बढ़ा रहे हैं, सब कुछ कर रहे हैं. I think it's very, very relevant. Somewhere we need to think through that these are specific cases. These are ideally exceptions. एक तो real estate की वैसे भी discussion is absolutely, it requires a different discussion altogether, a different forum, because the carve-outs, the patchwork for real estate is just not helping. Real estate requires a separate law unto itself. It can be a IBC, avatar, whatever for real estate, because the group insolvencies and the project wise and all those things. So I think wo patchwork nahi chahiye. And the class of creditors is nothing but more or less suitable, relevant for that. Now, even if we have other PAN card ki hum baat kar rahe hain, for example, this is one such case, one exception for which we cannot change the very basic premise of the claim submission. Otherwise, what will happen is it will be a message to all the creditors, irrespective. And let me also suggest, we say particularly in complex insolvency cases, I think ask the professionals who are here today. I think more than 50% will say, boss, case chota hai ya bada hai, complex to hai. So it's not about the size or the number of only the stakeholders or the creditors or the claimants. The process, because of lack of cooperation from all the stakeholders, lack of awareness, lack of sensitization, so many factors, the complexity remains. But that does not mean that for exceptions also we come out with rules like these. it is going to like, send a wrong signal. And if we continue with there, it says this increases the burden of the AA, leaving them less time to deal with more important matters. AA in any case is under pressure because of so many other frivolous litigations. Half the time adjudicating authority is interpreting. Half the time the communication between the two stakeholders is happening through the AA. They have stopped talking to each other. There is an application made and then there's a notice sent and that reply goes back to the other party. So essentially we are communicating through the adjudicating authority, and that's what's taking a lot of time. That should be addressed differently. So the pressure, the infrastructure issues, definitely, we are talking about, they need to be addressed. But the claim thing, somehow, I think it's really difficult to absorb, understand that this might actually throw this entire timelines to to air, because equally important, sir, you make these changes, the resolution applicants who were still concerned about the uncertainty of the finality of the claims continues to be an additional issue for them. So 90 days tak bhi agar wo nahi denge, that means we're not putting the onus. What is that limitation ka point? Ki somebody has to be aware of his rights. इसी टाइप से हम कहते हैं कि आप सो नहीं सकते अपने काम के लिए. You need to be very cautious and agile with regards to your own rights and your demands. तो आपको 90 दिन दिए, आपने अगर वो नहीं देखी public announcement, then there were ways to try and be still vigilant about your claims. Now 90 days is also less. Then few orders of NCLT said till the time the resolution plan is not approved. Of course, we continue to debate that the resolution plan has been given basis the IM, basis some certainty of the claims. But if till the time of the resolution plan is not approved, tab tak agar claims lete rahoge, how on earth a resolution applicant will keep making the changes? And if one creditor cannot discriminate another against another, what if a big bank, what if a otherwise any irrelevant guy but having a big stake, a big claim, comes in the 11th hour and says, nahi, mera to lena padega. Here's an order. I go to NCLT, I make sure that you accept. That can throw away this entire calculation and the viability of the plan. What do? The COC might have to get reconstituted. The RP will be in issue, will be in trouble. RA would be in trouble. Then we have a regulation which says you can't keep negotiating, right? RA cannot keep giving new plans. Now, if you keep throwing up surprises to RA, and what is the biggest surprise? IM is about the assets of the CD, but the claims are so important. Claim is the liability. What he is to address. Mr. Choksi, please, I suggest if you can mute yourself. Okay, sorry. So that is it. I think this is one. So it says extend the timeline for claim submission until 90 days from the insolvency commencement date or up to the date of issue of latest RFRP under Regulation 36B, whichever is later. Now, that is, I think, it's another challenge, because resolution RFRP thing, it has to come in the paper. If a claimant is not well versed with the public announcement initially, he's not even using the 90-day period, what gives us a guarantee that he'll be able to see this particular announcement, right? And at this stage, the revision applicant after the RFRP would actually start planning the plan, his plan basis the IM. So somehow, this just not adding up. I would definitely want, some views, from people. And other point here, which is equally important, it mentions the RP shall prima facie make a decision on acceptance or rejection of the claim. Now, again, the word rejection of the claim, we spoke about Swiss ribbons, we spoke about SR Steel, we said Supreme Court also expects or said that you do not have adjudicating powers, you only collate. What is rejection all about? So in this scenario, if you have to, put all the claims together and seek a condemnation of the AA, why would you even want to reject them? Because till now, the sense is keep collating, let RA figure out whether they want to pay or not, because you also need to give a reason why you need to reject. And you are actually putting up a reason for litigation. The moment you give a reason, the other party has no other way to, come back after you. The only way is that they have to reach out to NCLT that, okay, he's rejecting because ABC reason, but we need our principles of natural justice. We need to be heard. So somewhere I think it's just not adding up. At least I'm really finding it like, somewhere we need to really go deep, understand. Haji, Mr. Vikram Kumar, please.
So, Sanjeev, my simple point is that the suggestion of IBBI is actually going against the multiple orders passed by NCLT. Because the NCLT has passed multiple orders stating that the claim should be considered till, the plans are approved by the COC. So, how can the RP has no powers, especially adjudicating powers.
Yeah.
How can the RP decide not to, accept the claim or reject the claim when there are orders of court directing that he has to accept the claims?
So not acceptance is by default rejection. That's what I'm saying.
My point is, he has no powers to say that he will not accept.
Agreed. In
so
fact,
the whole suggestion of IBBI is completely redundant, number one.
Yeah.
And number two, it is again adding to a lot of responsibilities on the RP because the regulation says that the RP will file an application on behalf of the creditors for continuation of delay.
That's what.
So this is again absurd, I believe.
No. So that's the whole point. I said, like, something what a particular stakeholder has to do. Look, they are coming late. Agreed. They are coming late.
Unfortunately,
so they are at fault.
Sanjeev, unfortunately, I think IBBI believe that RPs are sitting idle doing nothing and keep on giving burdens on the RP. So point is that, giving burden on the RP is very fine. But where are the RPs being remunerated for it?
So this goes into a different tangent. Even if I was to pay 5 times, I would not accept these conditions. So let's keep the compensation part separate. It's a different discussion.
The point is compensation, I'm keeping it separate.
Yeah.
But the point is that number one, it goes against the orders of the NCLT. RP has no adjudicating powers.
Agreed.
So why to give a suggestion which cannot be implemented by the RP?
Absolutely. So so I think let's keep it macro until that also. Through that also we are able to
IBBI is creating more problems for the RP than to solve the problems of the RP.
I think our statement is to IBBI, who's also represented today, let's keep talking about the challenges, what these proposals might lead to, what are the better suggestions, right? Because it's not about they think that we are not doing anything or something. I think even if they have one case which speaks otherwise, then the onus is back on us to prove that no, we have enough work and we are actually struggling on the ground and there are challenges which are practical. So from that perspective, simple point is adjudication powers are not with the RP at all. So forget about rejection. I can't even accept. Somewhere I remember Mr. Mukhopadhyay telling you just need to collate, right? Which again has an issue. You just keep collating, put the entire thing, entire baggage to RA. And RA is probably grappling that, half of it does not make even sense. So from that perspective, I think you need to be cautious, but rejection and acceptance in this context is absolutely going to be a big challenge. Then collation and then making two separate applications, one saying that, okay, condonation. Why should I see condonation? That is a concern. That's a very relevant question to be asked. If there is a stakeholder who's obliged, whose money is at stake, whose debt is at stake, who is to come accept the law of land and be in the queue, whether it's a FC, OC, I don't care.
Because right? Sanjeev, I will make a small point. Sanjeev, I will make a small point.
Yeah.
The point is every suggestion of this discussion paper is an additional responsibility on the RP. If you see every point, there is an additional responsibility on the RP. Now IBBI has prescribed minimum fees for the RP, right?
Yeah.
That minimum has unfortunately become the maximum in the market. So the point is that additional burden is being now imposed on the RPs at what cost?
I agree. Again, you're bringing the cost factor or the composition.
No, that is the core point. That is the core issue.
I'll tell you what. I'm not speaking on behalf of anyone. I'm saying nobody is putting a
for
gun.
For every RP, I tell you, that is the core issue, that the minimum fee has become the maximum fee. And you keep on adding responsibilities to the RP.
Agreed.
And above that, the minimum fee is also not being paid to the RPs.
So sir, please appreciate this takes our discussion to a new tangent. I understand. It's not that we are talking
unfortunately, that is the discussion. That is the elephant in the room. Nobody is addressing.
No. So, okay, today's context, today's subject does not involve, we are talking about a discussion paper. And at the end, a blunt answer can be, if you don't like, leave it types. That is what the by default, message would be. So let us, as RPs, as professionals, I would say, let's just discuss and raise the issues. That's the best we can do as of now, because that's the platform. Let's restrict to the topic of the day. And the other point is like, yes, that's a burning issue, the payment, because everyone needs to be motivated. We all are professionals. We all need to be taken care of, ideally, we are a very important pillar. All that is fine. But I think some other forum will continue for sure. So please allow me that let this be a macro thing. So, for the representatives of IBBI, I think what we are doing is the stakeholders who are obliged to be concerned about their own rights and interests. And there is a law which gives them the power today to come and be in the queue and take the support of the RP, become part of the COC, understand the process, help him drive through. All that is possible. But do not take their obligation and put on the head of the professional. I think that is where it is not adding up, because if somebody is delayed and the reasons, you are not asking anyone the reason. You are saying if you are delayed, you are delayed. Just because somebody is not looking at the website or somebody is not aware of the CRP, how do I, how do I be responsible for that? I have to start at section 7, 9, 10, whatever it might be. The process is same. My role is pretty much cut out as an IP. I need to continue. Otherwise, my 180 days are never going to stop. And also, I make a repetition. Please appreciate the relevance of a stakeholder called resolution applicant. We are not helping the cause. Again, one particular case which we have been made privy to now, why this all started. I think that case, more than happy to be part of a smaller group. Let people come. We'll definitely want to spend some time. We'll help you. What can be done? What kind of a carve out is required for those situations? But please do not make changes in the main law, main provisions. It's going to be sending a wrong message, and it will be misused rather than any benefit for for the people. Because somewhere you have also mentioned in the paper itself, what are the cons? Potential for delays. While flexibility is a clear benefit, there's a risk that extended deadlines may encourage some creators. I am telling you, all the creators, sir, there is no sword on them to be active and vigilant about their own rights. I can't be running after them. And whenever they wake up from this slumber, they'll come back and say, hum to kar sakte hain because the regulation says so. And then it adds to the confusion, it adds to the litigation. The specific thing which wanted to avoid is not getting avoided by this mechanism. So somewhere I think this needs to be thought through and re-looked into. Similarly, you are also mentioning in the paper itself as part of the cons, number 2, added responsibility for IRP, RP. So we are saying, we are accepting. So please, and now you've heard people being very sensitive to this thing. Anything which is added to the responsibility, unless until it kind of, improves the process, but it should not be seen as somebody else is not doing what he was supposed to. Hence, the gap has to be filled by the IP. That probably is not the best approach. So that is a concern. I think, want to move. I think enough said. So more or less, I think we have. Mr. Jain, do you want to take just a minute and probably, quickly run through? I would need to move further.
Yeah, so in my view, the solution lies with the IBBI only. If you see the Rainbow Paper judgment, the 2 law officers of government banged RP like anything by saying that it is duty of the RP to maintain the records, blah, blah, blah. At the same time, law doesn't provide that RP can have any access to the latest what you call audited financial statement. Let government make a provision, like we discussed in the previous point. If that is available, at least RP can give something to the RA to show that this is as on date, which is given by the promoter. That could be the basis. So within that framework, RP can include that in the IEM and give it to the RA. So even if late claims are coming, to that extent, one can admit, and based on that distribution can be suggested. So I don't think there will be much difference except the interest component, which obviously promoter would not have incorporated. So I think solution is with the regulator. It is not for the RP. You say blah blah blah. It is not going to help. And case specific exemption can be made. That is not a problem.
That's exactly the point. Jab class of creators now, there are many claimants. I think we can always have a carve out. Sab logon ko ticket khareed ke station pe or airport pe time pe pahunchna hai. You can't keep delaying the planes and the trains for the people who wake up late or who get stuck in traffic. Unfortunate for them. Right, our heart goes out to them. कि अरे mehnat ki kamai, everything is fine. Like we accept that. But since the challenge or the obligation is now shifting to the professional, I think we need to speak that is a concern and is going to add to the issues. So somewhere somebody has to agree and fulfill their own obligations. Let them not get a feel ki jo bhi koi nahi karega to IP to kar hi lega. I think that probably should not be the message. So, I mean, allow me, I need to move further. Point number 4, increase of duties of AR. So broadly, when I read this, I think that's ideally a good thought. Now, how it evolves, we'll have to see. But AR practically all this while were taken as mere postmen, right? I mean, sorry to use this word. I mean, not to degrade. We're all professional brothers. But point is, the role was very, very limited, right? I mean, you represent whether it's 21,000 people of JP or a small group of 50 people of allottees or a class of creators, the role was very, very limited in the sense that even if my interaction with some ARs, even if they wanted to, I mean, move beyond and try and help, I mean, they were snubbed at times for reasons probably not best known to them, but otherwise also, because if you're not expected to do much, then somebody wants to get, be part of the IBC process. So let me be AR, kuch kaam to hai nahi, zyada dekhi jayegi, but not good. People who wanted to really contribute and make a value, make an impact, they were actually feeling pretty much, I mean, left out, that in spite of an AR, they don't have much to do. So I think this is in a very positive frame that you've, looked at this role. So role as an increase of duties, of course, I mean, it says duties. I would say powers kahin pe add kar dijiye, wherever you think they can take calls, but otherwise increase in duties primarily is better role, more meatier role, which also gets compensated accordingly as per the proposal. So from that perspective, helping the members in understanding the issues, increasing the marketability of the assets, so they can reach out, they can move around, they can speak to home buyers, they can collate information, they can interact, they can get to know the past history. The project might be languishing for 5 years and 10 years. What home buyers know, RP may not know, but AR having a regular interaction probably is a better person to kind of collect information, relevant information, which can actually help in marketing, and then communicating with RP, providing members represented, status of RP. Okay. So then recording minutes of such meetings, of course, that continues to be more of a transparency, consistency, record keeping, and all that. Helping in modification of resolution plan. So it's not that the way it is written always it will be that way, but essentially it tells you that the role is much wider, much meatier, and now the AR won't be sitting and doing nothing. You will have a lot of stuff which you can do, totally capped as per your initiative, I would say. You want to move out of your office, you want to keep interacting with those people, absolutely good. Even for your committee meetings, I mean, one is committee meetings where now AR will get compensated double the amount, which is a very good positive sign. Also for your meetings with the home buyers or the class of creators, even those would get compensated. You need to retain minutes and all that. So from that perspective, I personally have that view that it's a good thing. It says increase of the fees. It says then it says replacement of AR. Usme pas ek chota sa concern hai. Proposal says the creators in a class with 10% voting powers may seek replacement. I think that is too low a percentage. Otherwise what will happen is, I mean, ask me, I'm also a mediator. So when I do a community mediation, I think it's just impossible. I mean, in spite of you saying homogeneous group hai, all are allottees, sabka objective ek hai, 99% people expect, the allotment position of their homes, houses, offices, whatever it might be. But within those communities, within that homogeneous group, you have heterogeneous, smaller agendas, which really can play havoc. So 10% is too low a threshold. Otherwise, it can be misused by vested groups. And then it can again, derail this entire mechanism. AR will be at their mercy. So my suggestion, ideally, to dekhiye 51% hona chahiye of, again, the people present and voting. I think that's fine. You can't much help there. But 10% for sure is too less. So that's my quick view. And yes, so 2 hands raised. Can I start with Munishji coming for the first time, please, sir?
Thank you, Sanjeev ji. Now I have a very serious observation on AR being asked to review the minutes made by RP.
minutes being reviewed by the RP.
By AR.
हाँ, okay, but
Okay.
कौन सा वाला है साहब, ये एक बार बताएं. Sorry, I think I missed that.
Sorry,
उसने minutes अपने बना के रखने हैं. The idea was उसने अपने recording minutes of such meetings with the creators in class. He's not reviewing meeting. He's not reviewing.
AR shall also review the content of the minutes prepared by RP to ensure correctness and completeness. And if you look at the regulations, it says 16A11. The AR shall review the contents of minutes prepared by the RP to ensure correctness and completeness.
So this from the perspective was that, I mean, to an extent, I mean, I was involved.
Let me finish.
Yeah, please go ahead.
So the point is, when we say review is with a certain degree of authority.
Ji.
So are we suggesting that AR has an authority over and above the RP? Is AR getting into the supervisory role? 2. What happens when the RP does not agree with the comments or suggestions made by AR? How will that be tackled? Whether those reviews, comment will be binding on RP? 3. By the regulations framed by IBBI, RP the chairperson of the meeting. Now the minutes prepared and filed by chairperson are being reviewed by member of the meeting. Now that goes against all the protocols. And 4th, AR is like any other member of COC. You have other financial creditors sitting in there. You may be an OC without voting right.
Yeah.
If AR is given right to review, why not other COC members? Why are they giving special differential treatment to AR? This will lead to lot of issues. And this absolutely goes against all the protocols and minutes prepared by RP being reviewed by AR.
Okay. Okay. Got that. So, so you're done, sir? Okay. So if I read the proposed regulation, that's somewhere, it says point number 11, 16A में. The AR shall review the contents of the minutes prepared by the RP to ensure correctness and completeness. Now, the way I read, right? The way I read is AR represents a particular class, and with regards to the review of the minutes, because minutes would have 20 other agendas, but I think AR's limited review is with regards to.
Sorry to come in. I was not asking for your views. I want my views to go to IBBI officer. That's it. I'm not looking for your comments on it.
थोड़ा सा सब echo था आपकी आवाज में. In case you can repeat, please.
मैं कहूँ sir, I'm not looking for your comments on this. I want IBBI to take.
Oh no, of course. No. Okay, so I am giving you a very I mean a perspective which the way I thought, and again, like it's not your word versus my word. We'll definitely invite a IBBI representative who, if they wish to, they can respond. All I'm saying is, from my perspective, this was a review regarding his own space, because he's the person who interacts with the class.
Regulation does not speak what you are saying. These are you are adding the words from your side.
Yeah.
You are adding the words. Don't do that. Regulations have to be read as it is.
Okay, fair enough. So, because they are part of 16A, which was speaking about, but that's, I totally agree with you. So why would IBBI representative want to comment on this thing? I think it will be nice if any one of you can please unmute yourself and just let us know in case you have a different view. Anyone? Mr. Das, I guess, must have left because he had to leave for a meeting. So, okay. Anyway, Manish ji, दो चीजें हैं. एक तो organize.
Sir, can I just comment? I think what you're thinking
please.
is right, and in that manner only is what. So in the limited domain of where the AR is operating is what it has been intended to. We're not trying to, make it applicable to across all the things. I think what you explained is very well explained. I think that's the intent behind it. If you have any specific suggestions regarding the drafting of the regulations, sir, I will suggest give us the suggestions. The board is asking comments if you feel. That's why we're trying to put it on for public comments. So that if you have any suggestions on the drafting of that regulation, you can give us your suggestions or any apprehensions you have regarding that. Thank you.
ठीक. Okay. So उसमें देखिए immediate मतलब of course everything is getting like now prepared, collated by the the ICSI team. But here, maybe just for the added clarity for some people who may want to look at a very strict interpretation, कि इसमें लिख दीजिए कि AR shall review the contents of minutes with regards to the agenda dealing with the class of creators or something, because that's what
I to create difference, sir. Let every COC member have power to review his own agenda item related to him. Why a special treatment to AR?
Sab ye he represents a class of creators, no? ताकि
Then
उसमें ठीक बताया हो.
How does it matter? Only for the percentage of vote, everybody is equal. Other than for percentage of vote.
Okay. So I mean, okay,
Like, then let us adopt complaint of voter.
No, sir, वो point ठीक है.
Let him send the draft minutes to everybody. Let them comment. Let him.
Which happens. No, draft minutes वाला तो मुझे नहीं पता. That's a different suggestion, because 48 hours में आपको minutes देने होते हैं.
But 90 तो कर दो ना. 96 कर दो, कौन मना करता है? 48 का IBBI नहीं लिखा हुआ है.
हाँ, क्योंकि इसमें तो AR is a spokesperson of a certain category. उसको ये देखना है कि जो उसने बोला वो मिनिटाइज हुआ कि नहीं हुआ. The rest of the COC members are very much available in the meeting. So they are there in the meeting itself. But here, he's a spokesperson of a particular class, just to ensure. I mean, my view again, let's not, debate amongst ourselves. So I'm totally okay. I think we heard the IBBI representative also. The changes as suggested by you, some suggestions by me, they can get collated. Mr. Jain, aapka, you have your hand raised, please.
See, I have a different perspective or the view on this real estate or the class of creditors, especially from two perspectives. Firstly, the remuneration to the AR is still very less. If you want someone who can speak loudly and independently, you have to reward him appropriately. Still, this fees is very less. It doesn't commensurate the work which has been given to him. Keeping in the number of people he has to manage, even if he has to do online or particular physical meeting, it doesn't give any remuneration to him. So it remains more of a puppet in the meeting. And again, let us see the section itself. Section itself says AR has to come into the meeting after taking prior instructions. What you have provided in the act, it is not implemented in the regulation. You say just for the purpose of facilitating voting, you have given two stages of voting to the AR. Firstly, before meeting, and secondly, after meeting. If Act says the law provides that he has to come with the prior instructions so that he can participate well in the meeting, what is the purpose of voting after meeting? It remains a puzzle. If you want someone to speak, he should have authority and instructions before the meeting itself. You can't ask him that for the item voting will be done after that. Whatever the voting agenda item, let him take the instructions before the meeting from all the people or all the class. Otherwise, it doesn't make any sense. If half the people have voted and half the people will vote after the meeting, what the hell will he do in the meeting? I'm not sure. And this is practically happens. So he remains a puppet who is neither remunerated nor has any instructions. So I'm not sure why someone wants to have a person like him. If you really want to have a meaningful discussion and representation of the class, you have to reward the AR appropriately. Again, you have to make the arrangement of voting in a proper shape so that he comes with proper instructions and he speaks independently without any fear. So this is something what I feel one has to think of. Otherwise, it remains only a for namesake representation of AR, and we have seen what has happened in all the cases.
Okay, heard you, Mr. Jaswant Singh.
Sir, I fully agree with what Mr. Jitendra said.
Ji.
There should be proper authority should be given to the AR because the act only talks about he's a messenger, you rightly said.
Right. And
now new regulations are putting more liability on him to review the minutes. When he has no authority to say anything, why he should review the minutes?
No, that duty is being, imposed on him now, that in case he's said something on behalf of the home allottees or a class of creators, then that should be actually captured the way it needs to be captured. I think so that's more of a clarification, and this in any case was expected, right? Or no?
Yeah, I agree. It should be expected the person should, work diligently and professionally what has been assigned to him. And I fully again agree with what Mr. Jitendra said. There should be proper remuneration to be discussed about for the ARs.
Yeah.
Some authority should be given to them and some clarity about how the voting is done in the meetings.
So let's go a bit specific. I mean, some authority, what kind of authority are we expecting? ऐसे एक कोई example दीजिए. AR को क्या authority चाहिए होगी? He is a representative, authorized
He's a representative, yes.
To clarify, if I can intervene.
Yeah, please.
See, there is a voting item in the meeting. You are saying half the people or anybody can vote even before or after. If majority of the people are voting after, what AR will do in the meeting? He has no authority, no clear instructions, because the AR, the class of creditors will decide what they have to say after the meeting. So what is the purpose of such a person in the meeting who don't have any instructions on that voting item? Can he speak anything? No, because half the people have not yet voted.
No, so here we are challenging this entire mechanism of voting.
Of course, yes, voting in the class. How he can say that voting will take after when he has not?
No. So again, look, my simple point was, as of now, there is no discussion whether there needs to be a change in the way the voting happens for a class of creditors. Because had that been the case, we would have gone deeper. Here, what they've done, just clarified some more things which a AR can or should do. And in addition, and to compensate, they are making the remuneration double, plus coming out with something where they say, even for your creditors meeting, you know, one-to-one, there'll be some compensation. So I think that's, if we restrict ourselves.
No, even so it is necessary. How can you impose any duty on him when he doesn't have any instructions, clear instructions? You are asking someone that he will do some so and so, and it is his duty, but he don't have any instruction what to do. I don't know what to do in the meeting, but you are imposing duty on obligation on me. How can I do that? It is completely illogical. Firstly, you decide what I have to do, and that should be decided before the meeting. And if I don't act as per those instructions, then you can say I have not performed my duties. You're sending me without proper instructions, and you say I have a duty to so and so, so and so, so and so. So it's like, again, you have to carry out some work, but you will not be paid anything, or you will not be given any resource for that. It is completely illogical.
So somewhere you're saying the power and, you know, there is no parity between.
There is no parity. That's very true.
And there are duties out there. Okay, your quick views on the replacement. Would you see 10% as a lower threshold somewhere?
See, 10% is very low, especially in kind of this where there is a lot of what you call logging and what you call grouping by the promoters. So if you want to have at least, you have to have at least 25%. That is a reasonable number. Only then something should be proposed, because even it will have a cost implication. So 10% is like a company's.
Add one thing in this.
Yeah.
Like we, you know, say that when able to for the meeting, there should be 33% voting for the person to call the meeting. So we can add this. So for the replacement, there should be at least this much number of percentage.
Exactly.
You can propose this.
Make sense.
Same threshold of 30% should be there.
Yeah, right. Yeah. So I would, I mean, again, my own personal view, even I personally feel that 33% is the minimum. Otherwise, the lesser the threshold, it might lead to a situation of group baji and, you know, I mean, somebody influencing all that.
Why don't we do one thing? Why don't we take 51%? As it is in the other resolution.
Replacement के लिए, हाँ, मतलब देखिए AR. So again, let's say that it's more of two suggestions coming out from the group, 33 and 51. And I think in the best of their intentions and what they feel otherwise right, IBBI can, you know, take a call. But 10% for sure, the way it is mentioned is very low. And it's
10% में तो हर 10 में change होगा यार.
हाँ, exactly. मैं उसीलिए कह रहा हूँ ना. Then you are adding to the problem. क्या होता है कि एक AR continuity खराब हो जाती है. And we should be very mindful of the
one side you are giving him so much of responsibilities, and other side he is at the risk of changing.
Absolutely, you're making so vulnerable that, you know, anyone can just come and, like, you know, ask him to move out. And so that point. So I think again, you know, ICSI team, please make a note of these suggestions that ideally we should look at, you know, 51 or 33 as, like, you know, two numbers which have propped up. And then, like, you know, IBBI can take a, you know, the final call. Vikram,
one more thing, Sanjeev, one more thing. I think the remuneration to AR should be based on the amount of claim, as they have done in case of RP. It should not be based on numbers.
Okay, so as a suggestion, again, like, you know, that can be recorded, because RP के लिए तो मतलब समझ आ रही थी, मुझे नहीं पता AR के लिए. Of course, in real estate company where there's nobody else. Right?
I would agree
that AR is equally important. as RP is, because we figured out in few RP in CRP cases of pure real estate companies where there's no bank, right? No other FC. So essentially there's a 2 people meeting, right? AR and the RP sitting. So from that perspective, I think the load should be ideally, bifurcated and shared between the two. From that perspective, I would, again, my view that I would, recommend somewhere it should be in parity with the RP, because the roles are, from that perspective, very important of the AR as well. G.
I have one point to make here.
G.
Subdivision 19 says that creditors in a class may propose any additional responsibility upon the AR, keeping in mind its interest. Now that's opening a Pandora box. Now your class of creditors can keep giving you any responsibilities. And what will the modus operandi? Can 10% catering class come and say you do this duty as well? Or 1% can say, or you need 51% of them or 25% of them? This is something, there are so many open ends in these regulations. Look at 16.
Valid point, sir. Valid point. वो 33% वाला clause मेरा ख्याल उसमें भी आना चाहिए. The way in a normal CRP can be initiated by 33% of the voting rights. I think similarly, even to make AR do something different, additional or whatever, he needs to be, properly told. I mean, it's not that one person stands up and, starts giving him instructions. Otherwise, he'll be very vulnerable to all that. So,
and what kind of additional duties? There has to be some class of the duty that can be asked him to perform, and who remunerates him?
Ji.
Who gives him the money for performing those duties, additional duties?
No, so if there's an out of pocket, I think with the discussion with the RP, you can always.
It's not
on record, and then it will be in any case be put on the agenda item as a CRP cost. So, but no compensation. These are out of pocket we are talking about, because compensation is getting frozen or limited by the regulation. So I think that is something where it requires a different discussion. So again, I'm sure IBBI representatives are hearing all this thing. So let's move forward.
Sanjeev, I will make a very quick point.
Please.
If you read clause 17 here,
G.
The AR shall assist in modifications of the resolution plan
G.
as may be required by the creditors in a class he represents.
Right.
So can you explain, how can the AR make modifications in the resolution plan?
No, essentially okay. So again, I think it needs to be understood. He is a mouthpiece of a class. He goes back, explains them, this is what the resolution plan is all about. As it said, that he can always be the bridge between, so he's also helping in marketing. Then he's a bridge between the RP and the class. So there is few things which he understands in the RP. He goes back to the class, he tells. That's probably one of the reasons they are also wanting to compensate for specific meetings with the class separately. So it
he can't make modifications to the plan.
No, so okay. If the class understands the plan and the implications of the clauses in terms of the payment or any specific thing which is going to hamper or impact, they can always say ki aisa karo. So okay, the wording is assist in modifications. I think resolution plan to modify sirf RA kar sakta hai, if that is what you are saying. So wo language ka issue hai.
The point is that these kind of regulations coming from the regulator, at times, it's a very confusing
can play havoc, because a lot of people will do a strict interpretation, and I'm with you there, that the language has to be very clear, so that, which I said, half the time this goes back to NCLT ki sir regulation mein likha hai isliye hum kar rahe hain, right? So strict interpretation hoti hai, karte hain for people jinko ye suit karta hai. From that perspective, definitely, I also agree with your point ki hamari language should really be very clear with regards to our intent. Intent is, if the class operator feels that few things need to be changed in the resolution plan, then through the AR, they go back to the RA in a COC meeting, along with, of course, RPs there, so that RA can make those adequate changes in know of everyone, when there's a COC. So it's not assisting in modification. So I think the rephrasing has to be that he assists the class of creators to understand the plan, and whatever changes they propose, that needs to come back to the RA through the RP.
That is a completely different issue altogether. What you are saying is completely different.
No, but he can't modify the plan. The class of creditors can't modify the plan.
So that is what is the language here.
Exactly. That's what I'm saying. So the language, the way you read, strict interpretation, I'm sure the intent must be what I'm trying to kind of, I mean.
Sir, we are not concerned with the intent. Totally. We are concerned with the language.
With you. They're with you, because I say regulation will be subordinate legislation. It's a law of land. So somebody.
That is the limited point I wanted to make.
A point taken, sir. So yes, 17 वाला जो आपका clause है, I think this requires a rephrase as well. So I'm not spending more time on this.
No, even 16 is a problem. He has to represent class of creditors before NCLAT and NCLT. Now within class of creditors, there are different groups, and with the divergent views and divergent interests, whom will it represent? Especially in real estate allottees, there are always at least 4 to 5 groups in any big project. So whom he is going to represent? Group A, B, C or D? Which group will represent?
Again, I think percentage would be very important here.
How?
Yeah. No, I agree, sir. देखो ऐसा है. अब हम वकील वाली बातें कर रहे हैं, वो बात भी ठीक है, that you have to really see a particular sentence regulation from all the angles, because these have the potential of being misused. So I'm with you absolutely. I mean, there's no debate on these things, because we ourselves are sufferers at times. If I be the AR and I find myself in a similar position, then I understand what kind of a havoc it can play. Somebody might stand up and say, "Ki nahi, you, chahe hum 10 log hai, 20 log hai, doesn't matter. It's there in the regulation. You need to represent us." So I understand what you're saying. So I think the language probably needs to be more clear, more simple, more clear, and should only be interpreted in a one-way mechanism. We should not look at what in a larger context, or what is the intent, what is the need of the R, what somebody might be thinking. So the language should be as clear as possible. 16 और 17 दोनों ही हैं. So again, the team, please make a note that these need to be redrafted, and especially with the required threshold. We keep it open and it becomes a tug of war. So we need to be very cautious. And
I think the intent is that the AR doesn't remain a what you call puppet. And if COC, what you call the class of creditor to whom he represents as a COC member, he should speak, and if they want certain changes, he should propose or push up those things. So that being the case, I think that is the intent, so that he doesn't remain only in a puppet.
I agree, but you are not wanting to make him a puppet, but actually you are ending up making him a puppet. Earlier, he didn't have anything as a postman, and we thought he's a puppet, but actually now he can. Now he can become, because any class, as Minishji rightly said, any class, I mean, any members or a group from the members from the class can actually, take the benefit of this and say, you are obliged to represent us. We have a view which is different from the rest of the gang, the rest of the group, right? So then he'll be caught in a tug of war. So basically, क्या है, कोई threshold तो चाहिए. So similarly, जिस तरह से change करने के लिए चाहिए 33%, 50%, whatever. Similarly, if 33, 51, whatever be the percentage agreed, decided, till the time we don't have a voting, whether for replacement or to go to NCLT or to make changes or to do something like that, that's the time when AR, takes that mandate forward and represents. So somewhere I think those numbers will have to be. Look, this is a situation where we'll have to grapple with, especially in a case of a class of creditors. This may not be true elsewhere. Of course, they are not even required otherwise. But इसके लिए जरूरी, तभी मैं कहता हूँ real estate के लिए carve outs.
Yeah, you are right. But real estate has to be a case in itself.
Holistic देखना पड़ेगा. बस अलग से 2 chapter बनाने पड़ेंगे. Even if it means कि आपको, you have to repeat half of the IBC again from the code. But you still need to keep in the perspective that this is a real estate case. This is what it requires. These are the problems. These are the challenges. So we should look at redrafting or recompiling, few sections which are relevant, including regulation for that matter. Otherwise, all these points which we are raising are very relevant. And again, what we are doing is a patchwork. Because abhi kya hoga, abhi humne kuch bola. Quickly, we have come out with a potential solution. And you never know, once it becomes a regulation, and tomorrow, we have 5 cases with the new regulations going to the court and say, "Arey, humne ye nahi socha tha." So this again will have, it might be a bone of contention, but anyway, let me move forward. So we are already past the time, and that's that shows how important the discussions are and how much we need to discuss. But we'll try and wrap up in 20-25 minutes at best. So please allow me to be a bit faster, because two more points are there, 7 and 9, which require a more deep dive versus the the rest of them. So bakiyon ko I'll quickly pass through. 5 is inclusion of relevant minutes in Form H. I think that's a good suggestion. It's nothing but making it consistent, making it easier for NCLT to see ki COC minutes mein kya kiya. In any case, all the minutes we can give it to the NCLT. We are at times there are some practices where people do that. So, but more important is isme relevant minutes likha hai, so it can be more than one. It's not necessarily in the last meeting only we're discussing about the resolution plan. It can be more than one. It can be 5th and 8th and 10th and the last one. But whatever it is, based on the EOIs or RFRPs and all, I think let's put them all together, put that as part of Form H, so that it's on record. So absolutely, I think we should be okay. Point number 6, we are talking about addressing the aspect of limitation in applications for initiation of insolvency resolution proceeding. I think it doesn't require a debate. All we are talking about is put it on record so that half of the discussions or the fight or the challenges which happen in the open court are with regards to limitation. So to the extent an applicant can put everything on record, here is a default, here is a, here's a debt, here's a default, there's a chronology of events, this is what I told him, so it doesn't breach the limitation 3-year period, this, that, whatever. Let there be on record. We give them a summary, and the bench member is happy looking at a synopsis, and I think we should be good. So that's broadly okay. Important. Favorable voting on more than one resolution plan, point number 7. Now, I'll again share my views quickly on this thing, and then we'll open for a quick different views. So currently also the section 30 says RP shall present to the COC for its approval such resolution plans which confirm the conditions referred to in subsection 2 of section 30. Iska matlab, in a scenario, if you have more than one resolution plan which is eligible as per the applicable norms, whether in the code or in the regulations, you are obliged as the RP to put to the COC. Now, what should actually matter is the commercial wisdom of COC, where they run through all of them one by one all together. They call all the RAs. Totally, I think, dependent on the situation between the RP, his team, COC, their team, their due diligence guys, process advisor, whatever. And we should have stopped there. Now, there is also a reference that all the plans are to be put to vote simultaneously. Now, if there are more than one plan, and then somebody has to choose, then today the proposal says let's do a ranking in a way. Otherwise, all the plans have to be presented, all the plans have to be voted on. Now, simply put, if we were to keep things simple, we would have got a situation whereby one plan gets 90%, 100%, whatever. Somebody gets 75, 66, and then 50 and whatever. Now, whosoever gets the highest by default is the winner. And H1, whether it's H1 or whatever, COC in its commercial wisdom is adopted, accepted after negotiation. I think we are good. Let's go home happy. But somewhere there is a reference that the situation, hence it is observed that the creditors vote in favor of all the available compliant resolution plans to avoid being a dissenting creditor. But that was the need of the, because the plans which were eligible, which were right, which were, passing the threshold and the roster, had to be put to the COC, and they had to be put to vote simultaneously. That's part of, the earlier, provisions. So when they vote in favor of all the compliant, I think they are doing what was expected of them. And even if we are making it a preferential voting, still we are expecting them to vote on everyone. Now the only change is preferential. 1, 2, 3. I think the way we normally vote for a, in politics and in a this thing, ICWA ke ho rahe, to usme first preference denge, second denge. I think that is somewhere becoming confusing, because what exactly we are trying to achieve. Now, that is a point which we open up. I'll just quickly read few parts. The situation commonly occurs in several real estate cases where the real estate allottees vote in favor of all available plans in order to ensure that they are not dissenting creditor and the CD does not end in liquidation, as liquidation leaves the real estate allottees with no relief. Now, I think that is far-fetched. The other day, we also heard Dr. Sahu, and otherwise also we have heard that even liquidation, I mean, I'm not saying that's a good solution. It's a fait accompli. But even liquidation can be a solution for all we know. At times, maybe a better solution, but we are not committing on that. All we are saying is this situation commonly occurring in real estate can also occur in other cases also. A typical COC member who gets more than one plan, and those plans are to be voted all in simultaneously or one by one, whichever way, he'll vote in all. Because he might like, he may not like, he'll be a dissenting in some, assenting in some. Now, what exactly is the difference which is being made? So this real estate relevance or the reference to real estate is not making much of a dent, because ideally the scenario is similar for a non-real estate case also. So if I'm sitting as a part of a COC member, I have 3 plans, I'll probably vote on 3. And whichever plan gets the highest voting, I think that should be the plan which needs to move forward and to be given to NCLT. So that is one. And I think that's all I wanted to say, because now other thing, just a last quick thing, the explanation given with regards to the single transferable vote. Now, if I read it correctly, if I understand, then I need to, put it to you for other views. It says single transferable vote is a voting system in which voters cast a single vote in the form of a ranked choice ballot. Voters have the option to rank plans, and their vote may be transferred according to marked backup preferences if their preferred plan is eliminated, so that their vote is used to select a plan preference to that. I say first is okay, second is okay, and based on my voting percentage, it will get added to the percentage, and the third one I dissent, right? But in this case, it says your preference, transferable vote will move to the next one. I may not even want. And what if I've chosen one and that is actually eliminated because the rest of the gang in the COC has been dissenting? So to me, it really adds to confusion. And why we are now diluting the commercial wisdom of the COC, why we are diluting their process advisors, why we are diluting the RP who's sitting there with his own process advisors, required, not required, because they are people who have gone through the process, they understand, they know the objective of IBC, CRP, that we need to have a resolution. So by doing this, I think they're creating a lot of confusion with regards to the preferences, whether it's real estate, whether it's otherwise. Either you like something or you don't like. The preferential voting, the way it is explained to me, apart from adding a bit of confusion, it can throw up challenges. So, I mean, I'm not sure on this thing. I mean, I personally had my reservations, but happy to get more views. And of course, the IBBI all ears. Yes, Vikramji, your views?
My view is that, it's a kind of a forced resolution, not a kind of a voluntary resolution, but a kind of a forced resolution. That is point number 1. And second point is, if you see the last table,
yeah,
I think there is a typo error in the table. The voter for,
yeah,
the last table, the vote, because if you see, when resolution B, the preference vote of resolution A shifts to B.
This shifting thing actually was confusing, so I really kind of shut off my mind. I said,
no, I'll tell you
why we need to go into it, but I understand.
Sanjeev, the point is 4 plus 6 is 10, right?
Yeah.
So when the 4 is shifted to B,
yeah,
from A to B, the total should be 10. If you see the last table,
so
column
last
number
table,
4.
No, so actually last table is it's an illustration with 3 rows. And you are
I'm talking about the last table. The last table on that sheet, which is basically voting in favor of plan B.
Okay, give me a second. So rather than saying last, I mean, are you saying page number 12?
The point is, Sanjeev, there are 3 tables.
Yes,
in the first table, you have 3 plans.
Yes.
A, B, C.
Right.
C gets eliminated.
Yeah.
Then you have A and B.
Right.
Now in the second table, A and B, again A is getting eliminated.
Right. Because
so when A is eliminated, the 4 votes will go to
B.
B.
Right.
So 4 plus 6 becomes 10.
no, so here they're adding the first preferences only.
Yeah, I'm only adding first only.
Right. So if you see the first
Sanjeev, let me repeat. The column A has 4 votes. Just come to that column where plan A has 4 votes.
Yeah.
Right. First preference votes.
So you're talking about the second table, no?
Yeah, second table.
Agreed.
Resolution plan A has 4 votes.
Right. 4
B
ones.
has 6 votes.
I think what you should say is 4 ones.
Yeah, 4 ones only.
Preference.
I'm talking about ones only.
Right.
So it is 4:6.
Yeah.
Now all the 4 votes will shift to B.
Agreed.
So 6 plus 4 becomes 10.
So in the third one, it should be 10. That's what you're saying.
Exactly. So in row 4, voter number 4, you have one preference vote,
right,
which is not shifting to B.
Not shifting to B. Okay, which means in this case that he's given first preference to resolution plan A, the second preference to C, and B, he's been a dissenting guy.
No. So point is, it is a typo error in my understanding.
No, in the previous one, if you see,
it's not typo. Right? It's works like this.
It is same, because if you see the previous 2 tables, it continues to be dash against the 4th person under resolution plan B. It's a dash in first table and the second one. So that one means by default it's a dissenting guy. Look, I've understood the arithmetic of it. All I'm saying is, what was the need preferential? Because especially if you, as I went through the particular this thing, the definition of the single transferable vote.
So if I understand correctly, Sanjay, if you dissent to a particular plan, then the vote will not be shifted.
If you dissent, of course, if you dissent, then you are not there.
No. My point is that if a particular voter has dissented to a particular plan, then the preference vote will not shift to that plan, basically.
Look,
no, it will not.
You have to say 1, 2,
so if
3,
I've taken
4, whatever, and no, as in you are a dissenter in a particular plan. Now the shifting will keep happening after the least first preferences are to be weeded out, and then you keep moving up. So in case, I'm further complicated. In case you have said yes to something, but the rest of the people have said no, right? And they are in majority. Your yes also is irrelevant. Okay. So that also kind of, throws up a equally challenging situation, because your transferable vote, it says if their preferred plan is eliminated, it will move to the next one, which you may not have wanted for all you know. So
tell me one thing,
as you rightly said, forced resolution.
Okay. Now a point is, what will happen to the votes of the class of creditors? Will it be, a bulk voting, or it will be individually counted?
Somewhere, I think somewhere there was a mention that they continue to be governed by that 51% thing, present and voting majority thing, which then the AR comes armed with that mandate, and then sits and behaves like any other CUC guy with an adequate percentage what he has.
It's becoming very complicated, actually.
It is absolutely exactly the point I'm saying. So
very, very complicated.
So if 5 minutes we have spent on this thing with whatever little knowledge we had about maths and IBC and the resolution plan and happenings on the ground, I'm saying, why create? And what happens to commercial wisdom? Why suddenly we have said that, the COC is not even relevant, not competent, they are not aware. Again, if it is 1 or 2 cases which are again forcing IBBI or the policymakers to come out with something, I think let's have a carve out for them. And if it's a real estate, again, simple point, let the real estate not spoil the rest of IBC. That is what's happening. Because real estate is not helping, it's not getting the benefit, and trying to do a patchwork for real estate, we are neither here nor there. So let a real estate be a very specific kind of a charter culled out of the current IBC code and the regulations, which we need to debate. Let all the people who've handled the real estate cases be there, and the other people who want to be part of it. Let it be a half a day, 1 full day exercise, worth it. A lot of people are struggling, a lot of real estate is struggling. But now what we are seeing is the impact of that real estate is actually impacting the rest of the mainstream IBC. Right. So, and this particular, coming back to this particular point, I think, it's more of a consensus. So, our friends from IBBI, please understand it's really, a challenge. And you've heard, the views, and I think a one plain reading also kind of throws up what exactly are we discussing. Unless until we are very sure that it's a very straight line, which it is not. So somewhere, let's go back, in time and say, okay, the COC is having the commercial wisdom. Let's support them. Let's understand from them what exactly is happening, because here even RA is going to be like, pain. The first preference and the second preference. On one side, we are still grappling with, you can't negotiate with them more. Because, personally, on one side, you're saying we are getting lesser plans. The value is an issue or something. Why are we putting, a rigid mechanism on the COC or the RA not to be presenting their plans again more than once? If COC wants to maximize the value, the only way to maximize is through negotiation and renegotiation. The moment negotiation, renegotiation happens, which means it will by default lead to a small change, at least in the plan. And the small change in the plan, whether on the behest of the applicant or on the behest of COC, at the, it's amounts to the same thing. It's a change in the plan. So let's be very clear that, on one side, we're not creating hurdles, and we are, not exactly a red carpet, but almost. We need to have a red carpet for the applicant that, okay, we are making it easy for you. You come, give us the best value. We'll give you a clean slate. We'll give you a clean, ease of taking over, a smoother transition. COC, RP, authorities, this, that, everyone will be, helping you to, take it further, because that particular thing, the message which goes to the market is going to attract RAs and help more companies. These kind of things, right from RP to COC, is going to be adding pressure. I'm not saying that we won't be able to handle. Come out with this thing, we'll figure it out somewhat way. It's going to add pressure, it's going to add confusion. Not everyone will be having we will be in the same, frame of mind. People will say, it's very confusing. Aisa nahi karte. Let's only have one plan. Ek se zyada aayenge to mushkil ho jayegi, so let's have a simple plan. All these things will come to the fore. So, let's avoid. But from my side only that much. Yes, Mr. Jain, please go ahead.
Yes, so only thing, see, the regulator should understand how this process works. This is not a simple process where you can have a e-voting and it will be over. As we have seen in the voting of our institution, this is a specific mechanism. After total voting, but has to determine the threshold, and based on that, winner will be declared. So like in this case, the lenders who are still at the nascent stage of understanding IBC, if you put something like this, which is very complicated and they can't anticipate what will happen, because this is not a straight voting particular process. Companies, more and more companies, resolution will be delayed, and it will not simplify at all. Rather, it will send more companies into liquidation, because lenders will be afraid if they vote, what is going to happen, whether the second preference vote might defeat their feasibility and viability which they have done. So any plan which is not feasible, viable, or having S2 might come as a test one. So this is something one has to understand. It is not going to simplify the process. It is going to only complicate and delay the things.
Agreed. And I think very important point, which somehow I missed, I want to say that earlier. The plans are not exactly of the same shape and size, right? Not every plan speaks about paying up upfront cash. Not every plan gives the upside. So different plans will have to be viewed and evaluated differently on different parameters. Somewhere you lose some, you gain some. कहीं पे पैसा ज़्यादा मिलता है, but थोड़ा देर से मिलता है. NPV comes into play. There are at times, good people, strategic people, amazing brand after it, but they say मैं ज़्यादा पैसा नहीं. Because I understand, it takes a lot of time to resurrect the company, revive the company and all. Now you are in a very big dilemma as a COC. How do you evaluate? I understand you have a RFRP and the evaluation metrics and all, but it's not simple. We go back in detail. We have been part of those discussion, negotiation. It's really difficult. On top of it, then we say कि इसको ranking कर देते हैं. On the contrary, I would say weeding out is a much better idea. आपको 6 plans, if you have 6 plans, already the provision is all the eligible plans need to be put to the COC. Great. All the plans to be voted, whether you can vote them together or separately, leave it to the people who are actually at the hem of affairs. After that, in case there is a tiebreaker, you still can have, own parameters, thresholds की qualitative को ज़्यादा मैं weightage दूँ, quantitative को दूँ, upfront को दूँ, upside को दूँ, all those things. But this preferential thing is not helping the cause, because you are wanting to create a burden on the mind of a COC member कि ये first होना चाहिए, second होना चाहिए, third होना चाहिए. In their mind, they might have that kind of a sequence. But I think while discussing, while making it happen, and while reading this kind of a proposal, it really adds to confusion ki, pata nahi kya ho jaye. And I have to go back and report to the board, अरे ये आपने क्या कर दिया, आपने ऐसा नहीं करना चाहिए था and all. They come back to the RP, they seek more clarification, help us understand what exactly is this transferable vote, how would it affect, what is the implication and all. The poor guy like me will have to read and say कि ये मतलब है. So that means 20 people read it and कि ऐसे use करें वैसे करें. So unless until we are really sure about the benefit, I think we ideally will be better off in not getting into over enthusiastic by creating these situations, which to me are a hurdle. Again, my personal view, but yes, Dharmender ji, your view on this thing.
I agree, Sanjeev ji, and with other speakers. This is unnecessary and required at the moment, adding confusion, more chaos, and see not that intelligent. This thinking needs to be put down. COC members are very intelligent. They can make a choice, informed choice.
Right.
So, yeah.
Commercial wisdom, absolutely, number one. And then even if you're trying to address a particular exception somewhere, something similar in a claim as we discussed. So even if it's an exception, I think we should look at that exception specifically, not change the routine law for that. Right? I'm sure there is a way out. Maybe somebody has brought up a particular situation which is not fitting into the scheme of things as they are supposed to be today, which means we need to really, break our heads. But again, not to be not to be tampering or fiddling with the regular law as is being understood by people over last 6 years. Abhi thodi bahut clarity aayi, aise karenge. Again, there's a shift and somebody says, okay, boss, dobara se sochna padega. And ek aur cheez mein, matlab, as I speak, I'm saying, if their preferred plan is eliminated as is part of the explanation of single transferable vote, I'm saying even through that mechanism or an option of renegotiation, which the COC will always have, even something getting eliminated because of something, you are at times giving a chance to RA to kind of come back and renegotiate. अच्छा जी मैं आपको ये भी दे देता हूँ, अच्छा ये रहने देता हूँ, kind को cash कर देता हूँ, whatever. Till the time you are able to kind of look at a package, what you get with regards to the particular CD, I think it should be okay. So give them the freedom. Give them the freedom of picking up the resolution plan, which they think as per their commercial wisdom कि ये होना चाहिए. And then we should be not treading into their territory. I mean, that's my view. RP को भी बोला गया है कि भाई आपने eligibility देख ली, अब आप COC के सामने रख दो. If they ask something or if you have something to add value, you speak out. Otherwise, stay mum, because COC is all, it's a creditors in control. They are expected to know everything. Unka paisa laga hua hai. So why we undermine their intelligence or knowledge or something? So let's do that. Munish ji, last word from you, then I move forward.
It's not last word.
Maybe on this one. Go ahead.
See, my point is, I'll be keeping very brief. In my view, the preferential voting system gives more options. It does not close your options. It increases your options. I know now in present system, I only can either yes or no. Now I can say the first choice is Sanjeev ji, second choice is Jitendra ji. I get more options to say yes. If Sanjeev ji was selected by majority, at least I am happy with Jitendra ji. So that's what I believe it will be more options. That way the preferential voting system is a more preferred system of voting worldwide. But there will be some logistic issues that of course can be taken care of. There is nothing big deal in it. We are used to it in number of voting system takes place in ICSI and other places also. So that's my submission.
No, so fair enough. But आपका ये कहना है कि अभी yes or no होता है. So if I were to just stretch that argument, आज की डेट में if you have 10 plans which are eligible otherwise as per the evaluation matrix and all that, and you put all the 10 plans to the COC and the COC votes whether together or separately, and they say कि 4 हमें पसंद नहीं है, 4 are rejected, बाकी 6 हमें तैयार हैं, 6 पे आपने voting करी. Now, based on the voting percentage you get, you can always put a sequence. इसको 90 मिले, इसको 80, 70, 60. तो 90 वाला okay हो गया.
I agree. But my point is कि मैं अपनी preference पे तो बता रहा हूँ मेरे को कौन कम पसंद है, कौन ज्यादा पसंद है.
नहीं तो 90 वाला तो सबको ज्यादा पसंद है. मतलब 90 में 90% people want that plan to pass. और 60 वाले में खाली 60 people, 40% are dissenters. So that in any case is coming out of that current mechanism for now. So unless until this particular thing gives me something different which I didn't have. So today it says now they'll be putting a vote to all of them, which in any case they were doing. अभी उसमें ये था कि हम डिसेंटर ना हो जाए, बट डिसेंटर का और सब प्लान में वोट करने का कोई मतलब नहीं है. यू डोंट लाइक अ पर्टिकुलर प्लान आउट ऑफ 10.
डिसेंटर आप अभी भी हो सकते हो.
एग्जैक्टली, एब्सोल्युटली द पॉइंट. और सीक्वेंस देने के बाद भी somewhere even if you give a sequence as in preferential vote, you still can say 10 वोट हैं, मतलब there are 10 plans, मैं 4 को दे रहा हूँ, 1 2 3 4, बाकी 6 में मैं दे नहीं रहा अपनी प्रेफरेंस. पॉसिबल. अब आपने जो फर्स्ट को दी, आपने दी फर्स्ट को, लेकिन बाकी किसी ने नहीं दी, बट एज पर द डेफिनेशन ऑफ द वोट दैट गेट्स एलिमिनेटेड और आपकी फर्स्ट प्रेफरेंस बाय डिफॉल्ट सेकंड में शिफ्ट हो जाएगी, व्हिच यू मे नॉट लाइक.
So that otherwise happened with me right now also.
Sorry,
how did it impact me adversely? वो अभी भी होता है.
I didn't get that. Some echo, please say again.
I think that's happened still now also. I say yes to someone, other say no. He gets rejected.
तो absolutely the point. मैं कह रहा हूँ जो आज हो रहा है, होता है. So what exactly new we are doing? And generally the consensus almost, I'm not saying everyone, we've also got in detail and we've tried to understand, but generally consensus, why complicate? I mean, there is a complication to that. And if we can keep it simple, because simplicity will always help people, right? I mean, that was the whole idea. But again, I mean, we are discussing only to bring the positive and the challenging parts. At the end, we are not deciding anything. The conclusion ideally should happen when the IBBI is taking care of more such discussions elsewhere in different forums, and the way the collation happens by the ICSI team, they give it back and let them. So our objective today is to keep bringing out कि यहाँ पे issues हैं, and since this particular group is the professionals group, people who are on the ground who will have to grapple with this thing tomorrow. So if given a choice कि बहुत ही simple सीधा रखें जो चल रहा है, or we come out with something new which is not probably adding much benefit vis-a-vis what the current situation is. I think that was a debate, but again, happy to have all these views. So thank you. Okay, now change in timelines is something which doesn't require a discussion. It says some typographical error, and also, I mean, I'm not even going in detail. T plus 95 becomes this, that, whatever. So I mean, I think let's jump to 9th, the last one, which is again important. It will require a quick discussion. So audit requirement for insolvency resolution process cost in certain CRPs. I understand, appreciate certain. Then eventually it says 100 crore of SSS for the last balance sheet and all, number one. I think the most important point is what exactly was the need? Because transparency, it says, given the substantial implication of these costs in larger CRPs, the proper management and verification of IRPC is paramount for maintaining transparency and accountability, as well as for ensuring the financial soundness of the process. Now, it's a very generic statement. Maintaining of transparency and accountability is required in all the aspects in CRP and liquidation. Why, when we are saying that only the cost is relevant to be, to be transparent, to be consistent, to be on record? Accountability to IP ki sab pe hai. You can't even spend a single penny, right, without the approval of COC, number one. Okay, the accounts are audited of the CD irrespective, whatever be the stage. CRP cost is part of those accounting records. CRP cost has to be shared with the COC for approval or for ratification. So every which way, this particular cost was being accounted for, and reasonably, I think the best way, transparent, consistent, and records. The concern is, do we really understand what exactly is constituting the IRP CRP cost? I think that is the question which probably in couple of other WhatsApp groups and other seminars and webinars, when we raised this issue, we had divergent opinions. Now that is sad. This is more important a discussion rather than the audit. Usme audit mein bhi aata hu. My view again, as of now, the audit has to happen by a chartered accountant who is also an IP. Now audit word aa raha hai to CA zaruri hai. Lekin because ये CRP cost hai, to somebody needs to be aware of the IBC. Hence a CA who's an IP. Great, but are we putting IP versus IP? You are outside the system. You are a CA, you are an IP. I am an IP on the profession, on the job, handling a particular CD. You come back and say कि मैं IP हूँ, मेरे हिसाब से CRP cost ही गलत है. मुझे audit करनी है. I'll have to qualify. I'll have to disagree. This, that, whatever. So it's pitching one IP versus another in a way, and especially without answering my first query, what exactly is constituting the CRP cost? Now somebody, takes me back to section 5, subsection 13 of the code. It's a generic thing. It says various costs, including the remuneration of the RP, expenses incurred by the RP in running the business of the CD as a going concern, and costs specified under regulation 31 of the CRP regulation. It's a generic thing. कौन fit करते हो कौन नहीं. Process advisor की भी cost है, marketing की cost है, valuation की है, right? EOIs की है, public की है, whatever. Your team, your IP entity, everything. My concern is where it becomes a bone of contention is the expenses incurred by the RP in running the business of the CD as a going concern. Now that is a concern which needs to be answered. And please, IBBI team, you should actually look at this particular term. When a company is running as a CD is running as a going concern, right? Taking over a CD as a going concern or managing a CD as a going concern, the context is different. If there is a cash flow, if the company CD has been a going concern, you take it over and there are cash flows, then the cash flows from operations of the company cannot be taken as a CRP cost, which in cases we have seen, and it is difficult to get into a debate because it's like, our word versus somebody else. Essentially, if there is no funds available in a corporate, in a CD, and the funds are taken up as an interim finance by the COC or a third party funder, then by default, every cost is CRP cost because interim finance by itself is part of section 530. So anything what you spend, because the source of funds is interim finance, is by default a CRP cost. Whether you're paying salaries, employees, this, that, whatever, the rental, the insurance, because you have borrowed money with the permission of COC, that's the CRP cost. But if there's a cash flow from operations in a company which is a going concern, I mean, we have done it, and that's what the logic is. Because they get a revenue, right? They pay their salaries, they pay their insurance, they pay their operational cost, they pay the routine expenses, fixed cost, everything. And the CRP cost will only and only be the CRP driving cost. RP, the team, the professionals hired, not the salaries, not the insurance, not anything which regards to the company's normal operation. Now, this particular thing has been a debate in many forums, and we were slightly surprised. I mean, somehow we thought that we were clear and that was the way it had to happen. But apparently, unfortunately, people had different versions of CRP cost. So before we get on to the most important topic of audit, let us be clear what exactly will be the part of the cost. Otherwise you will have, all these issues coming in that, the CA will come out with a report, will say, this not, as per the norms and this and that. So I think let's be clear. This is important. And of course, the CA IP thing, I don't have much to say there because somewhere some thresholds had to be there. And so if audit has to come by the CA,
yes, sorry, I do agree. Am I audible?
Yes, Mr. Ranjan Chakrabarti.
Go ahead. The scenario may be different in cases where IP or RP is not getting fees and there is no assets. If another burden would have to be there to get the CRP expenses that will be actually will have to be audited, then in that case you have rightly pointed out that there should be some threshold.
No, so threshold is already there. It says, it's only applicable in a case where 100 crore rupees of the assets total value as per the last available financial statements. Now it can be 5 years old, 4 years old, or the current one. That's a separate discussion. With regards to the cost of audit, yes, even if it's a smaller amount, it does add to the CRP cost. So let's be very mindful of that because the cost in any case is reasonably, I think, very transparent. You are not spending anything without the concurrence or permission or ratification of COC. It's all on record. it has to be uploaded to IBBI. It has to be given here, there, everywhere. It's there, part of the NCLT reports and everything. It's part of the COC minutes. So nowhere there is anything which is hidden with regards to CR, because it's getting recorded transparently and also part of the larger cost of the CD, which gets audited by default. But I'm saying still, even if it has to be done, let's be okay with that, provided we are clear that what exactly will be constituting the CRP cost. Otherwise, there'll be a lot of friction between the so-called auditor, IP, because he's an IP. I mean, he might have his own view. Ye aana chahiye, ye nahi aana chahiye. Half the time, like, there's a other by default litigation friction happening between two professionals, absolutely uncalled for. So wo chota clarity, chota nahi matlab bada clarity chahiye. So two hands raised. We start with Mr. Ramachandran and then we come to Mr. Dan. Please.
No, small input I want to make. This audit is what they are proposing. It is prior to spending, or no? It is like reimbursement sometimes.
Post facto.
Post facto means, I mean, if they refuse, if the audit is qualifying that these are not to be spent, then will they recover?
Then you are answerable. No, you justify. Exactly.
No.
The point I'm saying.
No. Again, what I wanted to tell you, you were telling about, I mean, COC wisdom. COC approves it.
Agree.
And then another, see, AA is there. AA itself cannot ask the question to COC. Now we are putting one auditor. One layer is added now. Apart from all this, one layer comes in, it says, no, the expenditure, what you are approving was wrong. You should not do. I mean, for a moment, let us think they are refusing that these are not the admissible expenses. That is what always audit does. Audit is always only to create doubts, right? No, I
appreciate. Okay, no, I mean, you're taking it to the next level. I appreciate, sir. But my only concern was, audit is from the perspective that whatever you have done was legit. And I'm asking a question to myself, as we learned from Mr. Mukhopadhyay, asking question to ourselves, myself, that I actually took permission of COC before spending, right? Yes. Now, auditor cannot overpower the COC's wisdom, number one. And if it's a plain, simple exercise that, look, these are the minutes which are approving or allowing me, and this is what I have spent over the period. These are two things you can actually tick mark column A to column B, put your stamp, and if everyone's happy, then so be it. In that case, what exactly is the value addition of the chartered accountant IP? I don't see much. Okay. Yes. Even if it's a small certificate, then let me quickly suggest IBBI, please fix a fee also for this guy.
Another thing,
apart from the cost.
Hello.
Yeah.
Another thing, it may overlap the work of auditor in CRP process, because in CRP also audit has to be done.
But that's a larger thing, no? That's the audit for the CD as a whole. Here we are talking about only the CRP cost getting
only about CRP expenses. In case of
it's a repetition.
Also,
it's a repetition.
In case of liquidation also, that all the expenses are being audited, receipts and payments account are being audited.
Agreed.
So,
receipt payments have
so,
to be done. Yes.
There is overlapping of work. There would be, I
think. Absolutely. So that was my first statement, that I personally see it's an overlap. And even if you have to do, and just like, additional certificate, if at all, then please fix a fee. Otherwise, somebody will say, ki, since you spend 100 crores, so I'll charge 1 crore for that. 1% is my fee. That's not the way to work, because COC has already approved something. And I still go back to my previous, submission, suggestion, and a request. Please have a debate on what exactly is the CRP cost. Otherwise, people will put their stamp as a chartered accountant doing an audit, but you have numbers which are poles apart for a similar place CDs, because somebody is putting everything as a CRP cost and somebody like me is not. Because if there's a cash flow from operation, I continuously, as of now, believe they cannot be part of the CRP cost, irrespective whatever amount is to be spent, because the management's powers are suspended. Board, the duties don't suspend. If operations can continue, if I can get a revenue, which we have done. So if the revenues are coming, then the company has to survive by paying their own expenses, operational, fixed, this, that, whatever. This can't be taken as a CRP cost. Otherwise, it's a very wrong barometer of a CRP cost as a percentage of the process. Because what is CRP cost? Ideally is only the team, the process. And unless until there is no cash flow, which is a possibility happening in many companies, in many CDs, there you raise an interim finance. Now, right, I mean, half the time people are saying we're not getting paid. It's a different discussion, but that is the approved cost. That is that cost, whether paid or not paid, is a CRP cost. And anything which is like, funded through interim finance or by CRP, COC contributing, by default, it's a CRP cost. So let that distinction be there. And yes, Mr. Jain, your word on this thing, your views.
See, this is very interesting phenomenon. Firstly, you want someone to become the bank signatory, operate and pay, and he will remain responsible for anything goes wrong.
Yeah.
Anything goes wrong, he is responsible because he has not performed duties. But at the same time, you want to blame him that he is spending too much or he is spending without approval. Let us see one what you call Charter of Duties issued by IBBI in sometime in March 19. It specifically clarified in which case RP has to seek permission from the COC and on what cases no such permission is required. The concept of or the definition of CRP cost has been changing as per what you call regulators whims and fancies. I must say that even if you see section 513, what it says in clause E, anything which is not provided in A to D cannot be part of the regulation, but they have been doing, and again they want to regulate it. We have no problem, but we have to find a solution. If you think RP is spending too much, why don't you change the mechanism? Section 28 already says COC can impose a particular amount. Why you want to impose an amount up to which RP can spend? Let COC member become the signatory to the bank account. Let him operate and pay everything. If they think this is not something part of the COC CRP cost, let them take it. Let them take the heat. And if something goes wrong, so unless regulator itself doesn't want to correct its mistake, or it doesn't want to make the things smoother, one should not blame the RP. They're saying in cases of assets of say 100 crores. Anybody can tell me how many cases in terms of percentage are less than of 100 crores? These are all bogus balance sheets where everything particular debtors of hundreds of crores are being created. So in almost every case, this audit will apply. So what you want to say? Firstly, if you don't trust, make COC member a signatory to the bank account, let them pay everything. This is the simplest solution if you want to make the thing smooth, but they wouldn't do because COC doesn't want to take the burden because we all know how cost is being paid, how funding is done. It is a person who is signatory to the bank account. He has to answer to everybody why payment is not being done. So COC doesn't want because they don't want to fund it or there is no fund in 99% cases. In 1% of the cases where something goes wrong, they want to blame RP. And now they want to put a what you call this audit. Again, they made a what you call disclosure of cost disclosure. In each of them, they have taken the detailed breakup of everything month-wise or whatever you have spent. That is submitted to IBBI. Why you want such a vertical breakup? You can specify in that format itself. This item should be approved by COC. This item should not be approved by COC. Rather, you are asking RP to fill whether COC permission is taken or not. It is for the regulator to know what is a CRP cost and what is not. You specify, and based on that, RP can take permission from the COC. If COC doesn't give permission, that is okay. It is their asset. Let them suffer the heat. Asset is destroyed, distracted, stolen, whatever is the case. But this audit and all, it is of no sense. Again, we have seen half the judgment of IBBI have been stated by the High Court on the CRP cost. What is the purpose? If you want clarity, you as a regulator have to clarify yourself. What is the regulation intent of the regulation? What is CRP cost? What is not CRP cost? You make a simple and clear what you call regulation. We will follow that. But you don't want. We have written hundreds of what you call IPs would have written, I believe, what is the CRP cost? IBBI does not reply. Even in that circular, what you call circular or charter of 2019, what IBBI has written in case of any confusion, take legal advice. We take legal advice and you don't what you call accept that. So this is not the way. Even SEBI, if you see, they issue informal guidance to the members or various regulated entities. Of course, that is a paid advice, but they issue informal guidance. IBBI doesn't issue any informal guidance. IPA can't issue. So what is the solution? Solution is simple. You make COC member signatory to the bank account and let them pay everything. This is the simplest. So that is something a regulator has to go and they have to understand. Simply because few cases have happened where something has gone wrong, you can penalize those people. But just in the guise of those cases, you can't make anything which is very complicated and creates more panic and hurdle in the CRP itself.
True. No, I mean, that's well said. I think it's important that, wherever clarifications can come in time from the regulator, I think they'll definitely, help the cause for the stakeholders, especially for professionals like us. So as I said earlier, that, it's again inching towards, micromanagement. So telling what to do was good for professionals, that, okay, having a larger view, the sense of a larger objective, you tell them what needs to be done. But now coming to how, and each and every step getting too much regulated, it stifles this entire creativity, which is so important a trait, which is required for a revolution. None of the companies, irrespective of how much similar we think they are not going to behave, similarly, be it, the situation, the size, the people involved, the RP's team, the scenario. So there'll be a lot of the changes on the ground, which only you can appreciate once you are on the ground. So telling what to do, giving us a playground to play within the four corners of law, within the broad contours, I think that's good. But getting too much into specific thinking, ye karo, aisa karo, or when to take the first step and the right leg and the left leg, I think that's overreach and highly avoidable, especially knowing the background of the kind of people you are wanting to come in the profession. We're all with seasoned professionals. Now, as we heard, 1, 2, 3, 5, 10 cases, even if you take a percentage of 4,300 professionals, even if 1%, which is a good number, 43, play errant and they don't behave, ABC reason, right? I don't know, whether genuine or it just happens, whichever way, but that cannot color your vision with regards to the rest of this entire community, professionals. Equally important pillar, I would say. Otherwise, we are in for a more tougher times, but more or less, I think we are done with this discussion. And a small suggestion for IBBI, to the extent you find it relevant, let's see. Before we come out with these papers and before we put up a proposed regulation, if there is a possibility, right, you'll have to figure out how it works. The way we are having this session, and we wanted, to invite representatives from IBBI as well. Maybe by the time you are planning a paper like this, and at that point in time, if you come with the bullet points and we have these kind of webinar, seminar, small group meetings, couple of them, I think you will get a better grounds up view and a feedback from the professionals who are on the ground, who are grappling with it on a regular basis. The language, the proposals, how much needs to be covered, how much needs to be let go, how much creativity is required. I think all that will be helpful for you while you draft. Otherwise, of course, we get a draft, we'll definitely do our bit by getting engaged in these kind of sessions. But somewhere it shows that, there's already a mindset which has been made with some interactions which have already happened, either with a limited group or with, whichever way. So somewhere I think it's more openness required to that extent. So if similar situations occur in future, if we can have more of a draft which we were to discuss, then you come out with a detailed circular with proposals and all, it just might add to the impact. But any which way, I think some of them definitely wanted a tweak, correction, which has been there. But 3 specific things I'll just repeat for summing up. With regards to the preferential, voting needs to be thought through again. With regards to the claims being open-ended, definitely needs to be thought through. And the cost, the CRP cost getting audited, this also requires a tweak. These 3 are important, clauses which have, strong reactions from the community which you've seen. The rest of thing, I think these were important. They are the need of the hour. So to that extent, you have done your bit. Sorry, you've done your bit. And then I expect the team, at the back end, ICSI, IPA, they would have collated the views, the suggestions, and they'll, send you the white paper from our side before the time. So from my side, I think we are okay. We have definitely, gone 1 hour past beyond the times what we are supposed to. Anyone wants to quickly, have any suggestion or something? Otherwise, I think we have taken a lot of time. So I thank everyone, to have made this particular session interactive. And my views were my views. People have spoken about their own views and suggestions and all. I think everything should be taken in the right spirit, because we are all for the profession and the professionals, and equally important pillars. So we need to be heard, and we need to be taken care of as well. So that's from my side. If anyone has to add anything, Anu, I'm done. Or
so
yeah.
if anybody has any other suggestions or recommendations, if not, we can conclude the session. We've already over.
Absolutely, I understand. So I mean, I don't know. Maybe I need to be a better time manager next time.
No,
but, I think that's the way it is.
So I think it was a very interactive session, and a lot of recommendations and suggestions were coming in.
So please make a good note. Do share with us. Do share with IBBI team.
Sure, sir.
And
sure,
Mr. Das had to leave in a hurry because of his meeting, but I think it's important. आप उनको भेजें, and in case they need any clarification, so you can send those clarifications in a groups what you have, so that people can further clarify or share their suggestions. I think that's important. So let's close the loop for the benefit. Let's not leave the issues unattended, I guess.
Yes, sir. So we'll collate all the suggestions that we've gotten, all the recommendations. We'll share it with everybody, and we'll share it with IBBI. And if any further clarification is required, then we'll seek that too.
Perfect. So there's been a lot of chats. I mean, it's difficult to kind of go through all of them, I guess. So I mean, my suggestion: please reach out to the organizers. The team is here. You can write into them. If there's anything which we can do, we'll definitely come back to you. But otherwise, I thank everyone.
I'll put in my email ID in the chat box. If anybody has any further suggestions, you can send it to me. We'll collate it and send it all to IBBI.
Also, my suggestion: just speak once. I mean, yes, there are some people who will make a note of from the chat, but just speak the email ID once for people to make a note of it as well.
Okay. So everybody can share their comments at ankita.agarwal. ankita.agarwal at icsi.edu.
icsi.edu. Okay.
Yes, sir.
Okay, and plus you are putting that in the chat as well.
I'm putting it in the chat box also.
Great. TKG. So thanks a lot from my side.
Thank you so much.
Thank you for being, such a wonderful audience with a lot of interactions and suggestions. So, and thank you, the IBBI team. I think suggestions are taken in the right spirit. And thank you, everyone. Thank you.
Thank you, everyone.
Thank you.
Thank you, sir. Thank you, Sanjeev, sir, for taking out the time and for conducting such a wonderful session. We've received a lot of recommendations and suggestions. Thank you so much.
Thank you.